The case has been committed and city number I have not furnished. So I give the memo, your lordship may
Already disposed of.
dispose of.
Uploaded.
Uploaded today, my lord, morning. हाँ.
In the meantime.
In the meantime, city case. No, I said corona.
You try. It doesn't happen then you come.
PSK city case there.
PS case is already there.
The court name is there, no? In the magistrate court's name is there, so it is already in the ADJ court.
But the PS case is there.
PS case number is there.
You move application, why are you? It doesn't happen, then Monday mention. You try today, it doesn't happen, mention in the Monday. Don't worry. Huh? He may do it. If he doesn't do, Monday mention, I'll do it. On the same day, I'll do it.
If you have mentioned, session over the matter कर दे, court ना लगे.
Last day session over matter लिखा इससे.
हाँ कल अच्छा.
देख.
अपन देखो तो order में I know that this technicality, so therefore last paragraph लिखा इससे. Any mentioning? You mention what happened this?
And address was not corrected.
To pass it over.
Pass over.
What is, I don't know.
Item 1 and 2.
1 and 2 both. Yes.
Item 3.
Yeah, please, Lords.
Yes, madam.
My lord, this is a petition for passing of the GR case number 455/2021, your lordship.
Yes.
And the fact in itself means, my lord, the petitioner had no knowledge about the matter until December 2022, my lord. Whenever he applied for the passport, and only it came to the knowledge of the petitioner, and the FIR contains section.
That it is filed.
That's file not arrested.
Yes, ma'am.
Not arrested. Available tribal master offenses, my lord. Surrender.
No, it's not bail.
No,
No,
passing of
for
the
it,
FIR.
my lord. But in
Yeah,
fact,
yes,
my
ma'am.
lord, he has a charge sheet submitted not showing not arrested, my lord. But this, so far the co-accused persons are customer, they have been taken 41 notice, my lord. They availed that opportunity, my lord. Whereas this man, my lord, not availed that opportunity, for that in charge sheet submitted showing not arrested. And the offense, my lord, all the offense tribal magistrate.
No, tribal way magistrate doesn't mean that to
No, no, my lord.
passing.
Concern, my lord, he is one of the person along with the co-accused persons, those are assaulted with information.
The sections mentioned is not, the ingredients are not fulfilling, my lord. If we will
That
analyze.
it is at the cognizance stage, na? Cognizance has been taken.
Cognizance taken. That sheet has already been submitted.
So, what is for passing? What are the
Passing of the GR case, my lord.
no, what are the grounds? Mere passing doesn't mean that every case will be passed.
My lord,
It's not a routine job.
my lord, no, my lord, if we will analyze the sections one by one, that is.
So that will be done in the charge stage only. Not here to look at the section and the provision and all. Once cognizance is taken, you have to argue that on the charge stage only.
Yes, my lord, 41 notice has been.
No problem. You have been.
He may be directed surrender before the court.
My lord, he is a bank employee, so it may be speedy trial, maybe that.
What I'll do is the all other accused persons have been given 41 notice. You have been shown not arrested. And you go and appear before the court, and your bail application will be decided on the same day.
My lord, I'm just praying that the case should be concluded earliest possible.
Cognizance is taken. How can I do it right now? How many accused are there?
5, sir.
Yeah?
Right.
The dispute, my lord, in the garage of this petition.
How many accused are there? I can't.
3 to 4 accused persons. That is that matter maybe
Not arrested.
sorry, there is chances of compromise. Garage is side pillar with control is. That's you compromise.
Will you settle the issue?
Yes.
320, 323.
Settle the issue. I am issuing notice.
That cannot be
Yes,
Let me issue notice.
little better.
Settle.
But opposite but 2.
Settle
Notice
it.
to opposite but 2.
Opposite party number 2. Issue notice. Bring after 1 week I am releasing it. Bring him. I'll
They don't can
Yes.
don't apply this.
call him. Why to get into all this?
Yes, ma'am.
Bring it. File the requisites today itself.
When I said 2 working days.
I am 2 working day, but file it today. Then only you will file it.
Hello.
You file it and bring that complainant here. I'll pass the entire thing.
They take
Yes. Next.
Item 4.
Real, huh?
my lord.
What is the offense, sir?
Item 4. CD is not there, my lord. But in fact, my lord, 120 kg ganja, my lord. 20 kg ganja.
Adjourning to September.
CD, first time.
CD call for.
CD and CA.
Item 5.
May I please, Your Lordship? Custody since 35, 2023,
35.
23, 354B, 354A.
Recovery. Tell me the recovery. Recovery.
No, my lord.
Hey,
Under
yeah.
Ganja, na?
No.
No, 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 no. It
Here,
is
my lord, what happened?
354.
54.
Yes, my lord.
Okay.
Earlier, what
outraising.
happened? More than 1.5 months he is in custody. 1 year, 5 months, my lord.
164 is there.
One split is there, my lord.
3D.
But what happened in this case, my lord? The petitioner is the father of the victim, my lord. Minor. He outraged on modesty. For that reason, 498, 354 other offences registered against him. He is in custody. After release from custody, he taken liquor and also outraged modesty
Is
of the daughter. That for that.
That also. No, there is a dispute between husband and wife, for which, my lord, the wife,
Don't spare the daughter also.
For that-
yes, unnecessarily
What is it?
petitioner is in
Century of
dead
offense
also
is
ଆଜ୍ଞା
there.
ରହିଲାଣି
What is
dead
Dead also in the main matter.
ନାଇଁ ନାଇଁ ଏଇ case ରେ ଆଜ୍ଞା
After release from
See.
that case, again,
in
there are
that
conditions
case he is
not to threaten and
Then again he was taken into custody. And you release and bail, again you will do it.
no condition sufficiently ଦେଢ ବର୍ଷ ଆଜ୍ଞା husband wife dispute ହେଲା ଝିଅକୁ ଲଗେଇକି FIR ଗୋଟେ ଆଜ୍ଞା
Where from I'll get those things?
this is the case, my lord. I have given, my lord. The
Even
matrimonial case is pending, CP number 400 of 2022, my lord. Your lordship kindly peruse.
the matrimonial dispute is pending because you have created this stream in the house. Therefore,
ଦେଢ ବର୍ଷ ଆଜ୍ଞା ରହିଲାଣି 354 case ରେ
I know, but the father, no, that's the problem.
ଆଜ୍ଞା
So, look, what do you say?
condition
Initially, you were arrested when?
initially arrested 2 years back, my lord.
Give me the
5 to
date,
6, POXO Act, Section 80 and 12 in POXO Act, earlier case, my lord. After release from there, again he committed the
That
crime.
must be another offense.
Another same victim, my lord.
See,
Same,
ଆଜ୍ଞା
same.
My lord.
Why are you saying 1.5 years?
ନାଇଁ ଏ case ରେ ଆଜ୍ଞା
E-
ସେଥିରେ ଆଜ୍ଞା ବେଲ୍ ଦେଇଦେଲେ ବେଲ୍ ଦେଲା ପରେ ସେଥିରେ 2 ବର୍ଷ ରହିଲା ପରେ he was granted bail.
That will be not counted here. It is a separate
No,
case.
this is the separate case.
After
They
release
after
from-
release from custody, my
Another
lord.
case, another case.
Another
case.
case.
Same daughter, my lord, laws.
CD
Same.
is there. CD.
CD there, my lord.
164 photo.
160.
You are involving folks.
164 नहीं है क्या? 164 354 है इन्हें. 354 164 state. 164.
161 there, my lord. My lord. ମୋର ମା ଚାବି ଭାଙ୍ଗି ଘର ଭିତରୁ କେମିତି ପଶିଲା ଆଉ ଗୋଟେ ପଢିଦି ମୂଳରୁ 29/5/2023 ରେ ଉପରୋକ୍ତ ମକଦ୍ଦମା ତଦନ୍ତକାରୀଙ୍କୁ ଦେବା ବକ୍ଷ ବହାନ ଏହି ଯେ ଆଜି ସକାଳ 7:30 ଘଣ୍ଟା ସମୟରେ ମୁଁ ମୋର ମା ବ୍ରହ୍ମପୁର ଆମ ଜାଗପୁର ଘରକୁ ଆସି ଦେଖିଲୁ ଯେ ମୋର ବାପା କୁମୁଦ ମହାରଣା ଆମେ ରହୁଥିବା ଚାବି ପକାଇଥିବା ଘରକୁ ଭାଙ୍ଗି ଘର ଭିତରେ ପଶିଛି। ମୋ ମା ଚାବି ଭାଙ୍ଗି ଘର ଭିତରୁ କେମିତି ପଶିଲା ପଚାରିବାରୁ ସେ ଫଲ୍ଦି ଲାଙ୍ଗୁଏଜ ତତେ ଘର ଭିତରେ ପୁରା ଡାକିଲା। ମୁଁ ନ ଯିବାରୁ ମଦ ନିଶାରେ ମୋ ହାତ ଧରି ଘର ଭିତରୁ ଝିଙ୍କି ନେଇ ସେ ଘର ଭିତରେ ପୁରା କବାଟ ଦେଇଦେଲା। ମୁଁ
Sita magi thila arthar ko.
Acting the chemical report, my lord. Same thing, my lord.
Final charge sheet is filed or not?
Final charge sheet I have not, my lord, obtained.
Final charge sheet. Awaiting final charge sheet.
Final charge sheet.
Next 1 week after 2 weeks. Thanks.
Last occasion, your lordship, same thing was happened, my lord.
Last,
Se pathaise se
As-
final opportunity granted to the prosecution.
Case of 306, my lord.
You will get bail.
I see a final charge.
Next. 7.
May I please, Madam? This surrender certificate, madam.
Interim bail.
Yes, ma'am. Interim bail plus surrender certificate I am submitting.
What is the case? Surrender certificate taken on record. Next.
Mediation report already come and informant affidavit is there, madam.
Mediation.
Mediation successful.
Yes, madam. They got married and
You have to file it.
can file कर दीजिए, madam.
For the
Yes, ma'am.
what is the case?
373. taken her.
No, elopement is there due to love affairs, they got married, madam. Now they got married and
Mediation is there.
yes, madam.
In the regard being had to the fact that the dispute is between the petitioner and the
Mediation.
victim
Flag
who were
M.
relationship.
Court.
The mediation,
Flag aim.
no, mediation was sent by this court.
Yes, madam.
The matter was referred to mediation at the bail stage by this court. By this court, the mediation appears to be successful, and the High Court mediation.
District legal, district legal mediation center, Raigada.
District Legal Services Authority, Raigada, has submitted a report which is based on record. As per the report, both the parties and their advocates the report, para 7 of the report reads as under para 72 report. Both report dated 24/7/2023. ठीक है bail granted. Yes.
May I please, your lordship? My lord, hearing this case, the brief fact of the case is that the petitioner and the victim having a consensual relationship and the victim forced to get married. When the petitioner inclined to get married, this affair has been registered after 5 years when the victim,
Custody since
my lord, since 1/8/2023.
1/8/2023.
My
What is your age?
My lord, as per the affair, she stated when,
25. What is the age of the girl?
my lord, 20.
20.
1/6 there, my lord. But in fact, 373 there. For that, a notice is
Acha.
Notice already issued.
issued, but nobody appearing for
You-
that.
Nobody
My lord.
Notice
appeared.
was issued.
My lord, this, my lord, also Advocate General Office, my lord, send notice 12/2/2024, my lord. Nobody.
But
appeared.
you have not implicated her as a party in this proceeding.
And,
Where is the memo?
What date is allowed?
notice.
Madam.
that-
5/4/2024, my lord.
Huh?
5/4/2024.
That's right, but
Yeah, order.
you have to make her as a party, na?
Better.
Because the notice of the informant could not be heard due to non-filing of the complete requisites. In such we have to, you have not filed requisites also.
My requisites filed at the first occasion, it was not filed. The next we have filed the notice issued.
Last
accordingly.
order is not filed. In such view of the matter and counsel for the petitioner is granted 2 weeks time to file the requisites. And
My lord,
filing
in the
such requisites-
meantime, requisites filed and.
That has been sent, my lord.
Sent.
They have filed, my lord.
Notice? No, notice not sufficient. Notice not sufficient. Awaiting service of notice. Are you appearing?
No.
In service of notice, listed up to 2 weeks and implead her.
My,
If eventually it travels to some other court, they'll say that the party is not a party. Proceeding to the, and all these things you, proceeding nobody reads.
My lord, one thing,
Court
my
title everybody knows.
one thing, my lord, in view of the judgment upon Appeals Court, my lord, she has not mentioned the name, my lord. Victim, khali mention victim.
Victim, huh?
Victim herself,
Address.
address.
my, my.
You X address.
That-
Like that.
we-
Because you can't write.
No, my,
the name.
that's a big.
Item 5. Your lordship permitted to withdraw, renew my prayer trial court once again.
Item 5.
With a liberty to move once again.
On the changing circumstances, if such application is moved, same shall be considered on its own. Yes.
May I please, your lordship? Charge sheet has been submitted in section 498, 304B, 306, that for IPC mail.
Withdraw and liberty, yes. What is the offense?
May I please, your lordship? Charge sheet is submitted on section 498, 304B, 306.
304B. Show me
Six.
your
and
husband.
My lord?
Your husband,
No, my lord. The petitioner is the 7 years old mother-in-law.
mother-in-law.
My lord.
What is your role? You are in custody since?
ये खाली कहिला
Custody since
custody since 26/9/2023.
26/9/23.
2023. Well.
What are the allegations against you? Just see.
So far, allegation is the petitioner, my lord, as per statement of the Priyanka Parida,
Hmm.
only that person, my lord. ଗତକାଲି 24/8/2023 ତାରିଖ ଦିନ ବୁଲି ତାର ସ୍ୱାମୀ ପକେଟରୁ 2300 ଟଙ୍କା କାଢି ରଖିଥିଲା। ଏହି ଘଟଣାକୁ ନେଇ ବୁଲିକୁ ତାର ସ୍ୱାମୀ ଚୋରଣୀ ଏବଂ ତା ବାପା ଘର ଲୋକ ମଧ୍ୟ ଚୋରଣୀ କହି ତା ସହିତ ବୁଲି ସହିତ ଝଗଡ଼ା ହେଲା। ତା ସ୍ୱାମୀ ଏବଂ ଶାଶୁ ବୁଲିକୁ ଚରିତ୍ରହୀନ କହି ଖରାପ ଭାଷାରେ ଗାଳି ଗୋଲଜ କଲେ ଏବଂ ତା ସ୍ୱାମୀ ଶାଶୁ କହିଲେ, ସବୁଦିନ କ'ଣ ଆମକୁ ମରିବା ପାଇଁ ଧମକ ଦେଉଛୁ? ଯଦି ତୁ ଗୋଟିଏ ବାପର ଛୁଆ ହେଇଥିବୁ ଆଜି ମରିଯା ବୋଲି କହିଲେ। ଏତିକି।
What's the mother-in-law said that?
ହଁ।
For that,
Yes,
306 other offences are there, my lord, charge sheet submitted.
70-year-old.
Suicidal hanging.
70-year-old
Suicide.
woman.
That is suicidal hanging. Asphyxia caused death
The
probably due to suicidal hanging.
petition is actually open. Properly to the investigation has already been completed in the case and the charge sheet has already filed on 26/11/2023. Petitioner is in custody since 26/9/2023. The only allegation against the present petitioner, who is the mother-in-law of the deceased, is that there was a quarrel in the family on the on the on 24/8/2023, when this incident, when the deceased committed suicide. On that day, it appears that the deceased had taken 23,000 rupees from the pocket of her husband. Therefore, she was humiliated by the present petitioner and the family members. The petitioner alleged to have said the deceased that she has been threatening to kill herself if she thinks that she can do it. Let her kill herself. On the such it is alleged that on such instigation, the deceased committed the suicide. Regarding to the fact that the petitioner is a 70-year-old woman and the mother-in-law of the deceased, and the allegations are general in nature. She was actually since 26/9/2023 and or something. Yes, next.
May Presumption 60 kg custody miller 9/8/2023. 9/8/2023. A final PR submitted 28/12/2023 miller.
28/12/2023. When the bail rejected? Before charge sheet or after charge?
Final PR, my lord.
9/8/2023 miller. Extract order of
Thereafter, final PR submitted, my lord.
Then you have to go to it. I'll record it.
সেটি হলে হবনি
No, yeah, I am there. Trial court start exercising the power. You encourage the trial court to give bail.
37 বার কই হজুর হবনি
No, bar kole it is we are there. Don't worry.
কোন গোটে
We are
মাসে
there to
লাগে
give bail. Don't worry. Right now. The petitioner is accused in such and such case, and he is in custody since 9/8/2023. His bail plea was rejected on 9/8/2023.
Yes,
Same day. Same day. Investigation was also not taken up. Eventually, after investigation, the charge sheet has now been filed on 6/2020. The contraventions alleged to have been seized from the petitioner is about 60 kilo. 60 kilo.
without following the mandatory provision, the prosecuting agency.
60 kilo. I am not inclined to grant the bail to the petitioner at this stage because he has not approached the court below after the charge sheet is filed. Therefore,
After the final PR.
Final PR.
Final
Prosecution
PR.
report.
Final PR is filed. Therefore, the petitioner is granted liberty to approach the court of first instance, seeking raising his bail plea. Raising if such application is moved, the same shall be considered on its merit. Yes.
May please, Your Lordship.
Offense under 307 34 IPC. The petitioner is in jail custody since 16/11/23.
16/11/23. Okay.
There are 4 accused persons in this case. I filed the bail petition for Gopal Kantao. Other 3 accused persons released on bail by the Lawrence District Court. But the bail petitioner is rejected on the ground of criminal antecedent.
6 other criminal cases.
Criminal antecedent by rejected. In all 6 cases, I got bail.
395 most of it.
What are the nature of cases?
Started case 379, 380, 379.
Slowly improved. Petitioner got all
Then
cases got
slowly
bail.
improved.
All cases he got bail.
Where are the other cases? What is the status?
Status
Where
I
from
filed affidavit, Lordship kindly see.
Where is that affidavit?
In highlight.
Have you verified this affidavit? Mr. Agoda, have you verified this affidavit?
Pardon.
Huh?
No, I have not verified, but in fact, there are.
Verify. The petitioner has filed an affidavit dated 2/2/2024, enumerating the cases registered against him. The State Council shall verify the antecedent.
No, but my antecedents are with me, my lord. Also, case diary available. But he has mentioned one thing. Petitioner, all the cases petitioner released on bail, my lord. My lord, if he is in bail, my lord, that's directed the trial court, my lord. Verify the same, and he will appear before the Constitutional Police Station, my lord. Since 6 antecedents against him.
Only 395. What is the offense?
First case is 379, and that is year 2019. Then 19 380. Then 20.
How many accused are there in this case?
4 accused.
The petitioner is accused in this case along with the 3 other accused persons. It is contended by the counsel for the petitioner that all the 3 accused persons have already been enlarged on bail, except the present petitioner. The bail plea of the petitioner is rejected only on the ground that he has
having 6
criminal
accused.
antecedent. He has
6.
criminal antecedent. Criminal. The application was rejected on 11/12/2023. During the pendency of the present petition, petitioner has filed an affidavit inter alia stating the number of cases pending against him and the status of the case. Since the rejection of the bail application is only on the ground of antecedent, the petitioner has already disclosed the status of the cases, in which he is involved. The trial court should verify the contents of the affidavit and consider the bail application on merit. With this observation, the petition is disposed of. Yes, you go to that and verify and give it. Right. Next.
Item 12.
Yes.
The offense is the present petitioner Suraj Kumar Yadav, along with 2 other accused persons, has been implicated on the count.
What is the offense?
20B(c) of NDPS Act, sir. The quantity of the contraband is 44 kg 300 gram. Your lordship. Final PR submitted on dated 14 March 2024. Your lordship.
14 March 2024.
Custody since your lordship in September 2023.
Yes.
But what happened in this case, my lord? While this petitioner along with co-accused, my lord, they were juvenile. They carrying ganja and seeing the police, this person fled away. Juvenile arrested and sent to the juvenile justice board. And basing on the confession of the co-accused, this petitioner entirely
the juvenile
confession arrested this person. 44 kg.
Conscious position.
My lord, may mention final charge sheet PR submitted.
Not with me, my lord. PR submitted on
final PR. Final PR, my lord, not to copy, not me. He's saying that
final PR is submitted 14 March 2024, your lordship.
March or May?
March, sir.
Madam, petition is accused on the allegation against the petition is the petitioner, it is alleged that the petition, the 40 kilo ganja, na?
44
kilo.
300 grams.
From the co-accused.
44 kg 300 grams.
300 grams from the co-accused who was a minor. On his disclosure, the
He,
petitioner.
he was present, this petitioner was present there.
On whose disclosure, the petitioner is, was arrested. That the petitioner although was present, however, seeing the police, he fled away from the spot. The petitioner is in custody since 17/9/2023. Final PR has already been filed on 14/3/2024 regarding head to the custody and contraband seized, and the fact that the petitioner is represented on the basis of the confessional statement of co-accused, and he is entitled to pulse.
This seat belongs to Bihar, my lord. Additional
Bihar,
condition, my lord.
that right on the to allay the apprehension of the
Local security.
prosecution of the condition, outside condition. Yes.
Item 13.
Madam, to your lordship, my lord.
And Subho, that paragraph also, last paragraph, which I gave dictation. Yes. Yes.
Item 13.
Madam, to your lordship, my lord. Madam, offense under section, my lord, 363, 366, 3762 and 3763 of IPC and 6 of the POCSO Act, my lord. Petitioner is in custody since 9/9/2020.
73, my lord. Notice also, my lord, issued to the informant, my lord.
Notice.
Nobody appearing, my lord. Sufficient notice.
Sufficient notice. Custody since
9/9/2023, my lord.
23. Yes. Sufficient is there or not?
Police.
Whenever there is a service position, you just check it up beforehand.
And also, my
So
lord,
that we can waste time.
I think sufficient or urgent, my lord, I have not received the case diary, my lord.
Okay, is there not received?
Once
Is
it
not
was
received? Urgent. Okay. Next.
14.
May I please, my lord? My lord, in this case,
ಈ matter 9th September ಕೊರಕಿದವು 1 year ಹಿಡಿಯುತ್ತಾರೆ ತಾಪರ bail.
May I please, my lord?
After 9th September I'll keep 1 year you bail.
So nice hearing these things. Just music to the ears. My lord, in this case, the deceased and the petitioners are estranged brothers. Fighting started on ଇଟା ଆଣିକିରି ରଖୁଥିଲେ ସେଥିରୁ ସ୍ତ୍ରୀ ଲୋକଙ୍କର ଝଗଡାରେ ମିଳିକିରି ଗୋଟେ ସ୍କ୍ୱାବଲ ହେଇଗଲା. Both sides got injured, one succumbed to injury. 1 year ରହିଗଲାଣି. Your lordship kindly.
1 year, what is the position?
Charge sheet has been filed and everything is done.
Charge sheet filed, my lord.
What is the role of this man?
My lord,
Well, all of them.
All of them.
Because all brothers.
Who has the role?
my lord, three, my lord, the eyewitness there. And this petitioner assaulted mercilessly, my lord. 9 injuries. He has sustained
Santosh,
three, my lord, all three.
Lorna and
All three, my lord. 9 injuries, my lord, sustained the deceased, my lord. And out of 9, my lord, 2 injuries, my lord, the vital and a death due to craniocerebral injuries and their complication thereof, my lord.
what are the weapon?
Weapon, axe, iron rod, and a stick.
What is the
That has been
who was holding what?
But that is not specific, my lord. But in fact, the eyewitness stated that all three assaulted the deceased mercilessly by holding the weapon of offense. The lady members given all the weapons to the male accused persons, my lord. Their family members. They are also represented as the accused person. They have not been arrested. But in fact, there are allegations, my lord. Direct allegations there, eyewitness there. They have stated that they had seen.
How many eyewitnesses?
And there are, my lord,
35.
none, total 35.
No,
Out of them, my lord, one.
Tell me the eyewitness.
My lord. My lord, the family members also eyewitnesses and the independent eyewitnesses, 2 independent witnesses, my lord. Near about, my lord, 4 to 5 eyewitnesses are there, my lord. All of them seen there.
Wait till the eyewitnesses are again.
My lord, no dispute that that was.
I will 6 months eyewitness. 6 months eyewitness. All he can revive his renew the bail plea after the eyewitnesses all the eyewitnesses are examined. It is expected that the trial court should do well to see that the eyewitnesses are examined preferentially over the formal witnesses, and if the testimony of eyewitnesses could not be recorded within 6 months, the petitioner can revive them.
Much.
It takes 6 months to record.
15.
And the bail application to be moved after the expiry of the period as indicated above shall be considered on its own merit on the basis of available record. Yes.
15 May periods.
On the basis
Offense
of
under
available record, then.
May periods. Offense under section 302 506 IPC minor. Initially, FIR was registered 307 and then turned into 302 and 506.
Yes.
And then,
The victim was not lucky.
minor.
302.
Assaulted by means of FIR allegation was assaulted by means of lathi.
Lathi blow.
Minor.
Custody.
Custody is 27 November 2023.
23. And lathi blow in the head.
My lord.
No, death, lathi blow, death means head only.
But,
Otherwise, he will not die.
but 164 of the one eyewitness
Hmm.
says, my permission.
Yes, yes, the relevant part.
ଦିନ ସନ୍ଧ୍ୟା 7ଟା ବେଳେ ମୁଁ ଚିକେନ ଅଣ୍ଡର ନାଇଟ୍ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଘରୁ ସାଇକେଲରେ ବାହାରି ରାସ୍ତା ଉପରକୁ ଉଠିଲା ସେଇ ସମୟରେ ଡିସିଜ ନାରାୟଣ ନାୟକ ପଛପଟୁ ତାର ପିଠିକୁ ବାଡେଇଲା ସେ ବୁଲିକି ଦେଖିଲା ଯେ ନାରାୟଣ ନାୟକ ପଛପଟେ ଛିଡା ହୋଇଛି ତାପରେ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ବୁଢାର ଆଖି ଓ ପାଟିକୁ ମୁଥ ମାରିଲା ଓ ଜୀବନରୁ ମାରିଦେବ ବୋଲି କହିଲା ବୁଢା ପାଟିରୁ ରକ୍ତ ବାହାରିଲା ତାପରେ ବୁଢାର ଝିଅ ମାନେ ଦୌଡ଼ିକି ଆସିଲେ ବୁଢା ତୁ ଆଜି ବଞ୍ଚିଗଲୁ ଆଉ ଥରେ ତୋତେ ପାନେ ଦେବି ବୋଲି କହିଲା ଝିଅ ମାନେ ବୁଢାକୁ ଘରକୁ ନେଇଗଲେ ତାର 2 ଦିନ ପରେ ମୁଁ ଶୁଣିବାକୁ ପାଇଲି ମାନେ this is dead.
But the old man, you are 18-year-old boy. How many eyewitnesses?
There are two eyewitnesses.
Same karo. Eyewitness 6 months. Eyewitness 302. Okay. 16.
There is a present petition in my name, my lord. I have appeared, my lord. And file wakalatnama.
Petitioner.
Present petition, my lord.
Okay, list it after 2 weeks. He's filing wakalatnama. Yes, next. 17. File the wakalatnama and record, huh?
File
Each of copy about petitioner and give the name in writing, huh? File the wakalatnama.
My name is there, nothing.
Name is there, huh? Okay. On request. Yes. 17. Yes, sir. 17.
May I please, sir? And this is the custody word since 16/7/23, my lord.
16/7.
Yes, 23.
Okay.
Charge sheet file, my lord. 16, my lord.
FIR offense.
302-201-120B.
Yes.
Petitioner is not named in FIR. Unknown FIR, my lord.
Huh?
Is not named, unknown FIR.
Paju bhoi. Yes, sir. Yes, sir. What are the evidence?
Confession before the police and
Confession
by this petitioner before the police.
how you were arrested on suspect.
Suspect, my lord.
Okay.
On police custody, he confessed that.
Except confessional statement, what do you have?
Another thing, my lord. One video.
Don't say 27.
My lord.
Don't say 27. 27 and confessional statement.
My lord.
Apart from that, what do you
Yes,
have?
my lord. Excluding
The
that.
video was recorded, my lord. In the video, it was found the petitioner along with others assaulted the deceased.
And let us see what
My
you
lord.
have.
My lord,
Evidence
excluding that, my lord,
Huh.
one statement of eyewitness is Monam Netta Paiko. He is the wife of main accused.
Okay.
What happened? May I read, my
Main
lord?
accused.
Main
May I
accused,
read, my lord?
main accused. How many accused are there?
There are 4 accused.
Four accused persons, my lord.
Okay.
मोर नाम नेत्र पाइक आपण पाखर मोर मगे जे मोर स्वामी रो नाम होचे आकाश पाइक मोर इट इज अ वाइटल आई विटनेस
Read it, read it.
मोर स्वामी और सूरज दास दुहे भलो सांग हेसन सूरज दास इज डिसीज
This is, I understand.
गत 11/7/23 दिन मोर स्वामी सूरज के मोर संगे मिसुचे बोली संदेह करी मते बहुत रागिले और सूरज भी रागिले मुई मना कली मोर तार संगे किछि खराब संपर्क नाही न हेले भी नाही मानले गला 13/7/23 दिन संध्यार मोर स्वामी तरुण और सूरज आमर घर के आइले आम घर रे खाइले पीले तरुण पलाला सूरज और मोर स्वामी सोइले तार पर दिन 14/7/23 ऊपर बेला सूरज और मोर स्वामी दुए बाहर के गले और तुरंत घर के फेरले
আমার মোর স্বামী শুইলে সুরজ মোর স্বামীর মোবাইল ধরি পলাইলা মোর স্বামী উঠিলা পরে সুরজ কে খোঁজি করি আনিলে আর আমার ঘরে বহুত পিটলে আর আমার নুয়া ঘরে তাকে রখিলে মুই ন মনা কলি নাই মানলে তার কিছু সময় পরে কাজু भी আইলা কাজু হিজ পিটিশন
What is it?
কাজু भी আইলা আর মোর স্বামী কাজু আর মোর দেড়শুর বন্টি সবে মিশি করি সুরজ কে পিটলে আর পিটিবারটে মোবাইল রে শুটিং কলে
Oh.
মুই না মনা কলি নাই মানলে রাত্রে কাজু মোর স্বামী বন্টি আর সুরজ
Let this eyewitness examine.
Yes.
6 months, same.
But,
After eyewitness examine after or 6 months. whichever is it.
that is the statement my friend is reading.
She is a eyewitness and the wife.
of one of
And
the
the entire dispute is because the husband started doubting that she has an affair.
With this, the deceased minute.
Yes, and thereafter mobile shooting. Have you recovered mobile?
yes record and according to the 27 statement my lord the weapon has been seized and also the postmortem report is supporting to the
Not seized from the petitioner, nothing has been seized. So see the list I am reading.
Whatever there is eyewitness. Let us see. After the examination of eyewitness, 6 months, whichever is it. Here.
Now the case is committed to court of sessions.
Yes, no problem.
Let's at least 3 months so you can bring
No,
out the commitment.
Whichever is earlier, I'm saying. I'm giving a direction also that the eyewitness should be examined preferentially over all the witnesses. First, she will be the first witness.
Naturally.
एक ही तो eyewitness.
But the statement is that is believable. The implicating the.
See this eyewitness is hostile, then you're out. Wait. Yes.
my lord in 18 is also 302 matter my lord CD has not come.
This
And
matter was there
excluding-
yesterday, your lordships, and I'd given a list of matters to come along with. One of them has come in fact, but the other.
अच्छा सारे लोग इधर PD you call for नहीं I
Yes,
think
ma'am.
they have come in other matter.
Definitely
I have
my lord.
given the
Definitely.
list there yesterday as well.
हाँ
I've given another list today. Hopefully, I
all the
will be
matters
lucky.
list together and just check it up if the CD has come in any one.
CD has
one of
come actually. I've got the information, it has come.
Come.
But which matter, that is a,
maybe in one of the matters.
yes,
maybe.
that is the reason I've given.
Let us model
It'll come together. You just kindly get
List it, huh? All the matters.
lordships.
My
May
lord,
please your lordship.
19 also 302 and CG are not received.
CD. Okay, call please.
Yes.
Then the CD.
But add them lecture.
Yes. Anybody? 20? You are there? Okay. Please come.
Initially, the case was.
Offense?
Initially, the case.
306
306 now, after charge sheet 306, Millers, the
You are-
petitioner is in
Who are
custody.
your husband?
I'm the husband.
Just a minute.
What about the other?
They have not been charged. 3 persons were named in the FIR. Charge sheet was filed only against the present petition.
What do you say, Mr. Rao?
My lord, my prayer before your lordship, my lord, CD is available, my lord. In the last occasion, my lord, but what found there is that the postmortem report is not there. Whether the postmortem report has been recorded, it is doubt. So
Just verify.
in
Just
that
verify.
regard, I have to verify.
I'll list it after.
Yes, sir.
After 1 week.
Yes.
Say date may be kindly be
Date
given.
will be fixed, don't worry. I'll dispose it up in this coming 15-20 days, everything. Don't worry.
Grateful, Millers.
Yes. Note it down and I'm not writing anything, huh?
Yes, no, my lord, definitely I will obtain it.
21, yes.
Case under section 302, custody since 19/8/2023.
My lord.
Yes.
Okay.
My
My
lord,
lord.
here what happened, the go and call those.
Yeah,
ମୁଁ
CD is
ଆପଣଙ୍କ ପାଇଁ
there.
କହୁଛି
CD,
ରାୟ ବାବୁ ମୁଁ ଆପଣଙ୍କ ପାଇଁ କହୁଛି
CD is there.
My lord, I am very much I beg pardon to your lordship, my lord. I have received yesterday's night to ensure let we all are.
I'll put it next week.
My
Yes,
lord,
so
there
that's
is
my
nothing,
little
there is
prayer.
nothing.
But he
I am
has-
little
and
prayer.
he-
I could not.
CD has been called. He's entitled. to-
My lord, there are 3 eyewitnesses. Those eyewitnesses have been hostile. I have
One week
filed.
only.
Next week I'll grant bail. Why
Yes,
do you worry?
absolutely right. My friend has told That exactly.
Let him have this.
We have received, my lord, 11:30.
This system has changed now, so they are feeling problem.
Tuesday, your lordship.
Okay, no problem.
Tuesday. Because see,
Yes.
why I am keeping it Tuesday,
Yes,
is
ma'am.
everybody is hostile, so why should?
Yes.
Tuesday.
हाँ सब अच्छे.
ଷାଠିଏଟା ଅଛି ତ
हाँ सब अच्छे.
deposition ଟା?
मतलब आपको भी बताइए.
ନାଇଁ.
This is how the democracy works.
Yes.
What to do? Yes.
କଣ କରିବା ଫାଇଲ ଦେଖିଛ ନା ଦେଖିନ?
Total देखुଛି.
ନା କହିଦଉ
It is very problem.
ଦେଖିନଥିବେ ଯେ
If you are not, I'll put it next week. Don't worry.
କେତେ ସେଟା 21
21 ଟା ଗଲା 22 ଟା
22.
22 ଟା ଦେଖିନଥିବେ?
22 ଟା ଦେଖିଛି.
Yes. Custody. What is the offense?
My lord, offense is 376.
376.
My lord, 506, 507, 509.
IT Act is also there.
IT Act.
You see, 164 reads here.
Yes,
Custody since
my lord.
custody.
I may.
My lord, the petitioner was arrested on 6/2/2024.
Only. Okay.
ଟିକେ ମୁଁ 164 ଟା ପଢି ଦଉଛି.
No problem.
ନା 164 ଟା ଦେଇ
Details
ଦଉଛି.
ପଢିବା ଦରକାର ନାହିଁ.
ମୁଁ ପଢି ଦଉଛି. ଅଛି ମୋ ପାଖରେ.
The last portion ଟା ପଢନ୍ତୁ.
Prior that only.
Videography କରିଥିବେ. କରିକିରି
Yes. My
ତାପରେ କଣ
lord.
ହେଲା ସେ
The most tragedy one.
376 is all right.
No, my lord. The
376
victim is my lord.
must be in relationship. The same story.
Definitely.
Relationship, photograph.
Victim is 27 years. 27. What she has
The pathos thing is there that victim is the friend of the daughter of accused.
ହେଲା
What is the age of
ମୁଁ କହିଲି
your age?
ମୁଁ ପଢି ଦଉଛି. ମୁଁ କାଜଲ ସିଂ +2 କଳା ଏକା ସାଙ୍ଗରେ ପଢୁଥିଲୁ. ସେଠାରେ ପଢିବା ସମୟରେ ଆମ ଦୁହିଁଙ୍କର ଘନିଷ୍ଠତା ବଢିବାରୁ ସେ ଆମ ଘରକୁ ଆସେ, ମୁଁ ତାଙ୍କ ଘରକୁ ଯାଏ. ଆମ ଉଭୟଙ୍କ ମଧ୍ୟରେ ଘରକୁ ଯିବା ଆସିବା କରୁଥିବାରୁ ଆମ ଦୁଇ ପରିବାର ମଧ୍ୟରେ ଭଲ ସମ୍ପର୍କ ଥିଲା. ଏହିପରି ଆମମାନଙ୍କର ଭଲ ସମ୍ପର୍କ ଥିବା ବେଳେ ଗତ 2019 ମସିହାରେ କାଜଲର ବାପା ରାଣା ପ୍ରତାପ ସିଂ ତାଙ୍କ ଭଉଣୀମାନେ କାଜଲର ପିଇସି ଘରକୁ କଟକକୁ ନେଇକରି ଗଲା. ସେଠାରୁ ଚୌଦ୍ୱାର ଜଣେ ମୁସଲମାନ ଗୁଣିଆ ପାଖକୁ ନେଇକରି ଗଲେ ଓ ସେଠାରେ ହଁ ଆଜ୍ଞା ମତେ ଝଡେଇଲେ, ଝଡା କରେଇଲେ, ମୁଁ ଶୋଇପଡିଲି. ଏହିପରି ଭାବେ ପ୍ରତ୍ୟେକ ବର୍ଷ ସମୟ ସମୟରେ ସେ ମତେ ଚୌଦ୍ୱାର ନେଇକରି ଯାଆନ୍ତି. ସେଠାରେ ମୋ ସହିତ
This is the only allegation, and this person is.
My lord, I am praying before your lordship, my lord. This matter 420, 467, 468. And my lord, 120. It is a financial transaction. What I have been instructed today's morning from the concerned IAS man. Along with this case, my lord, there are other 3 cases are there.
Against this man?
No, the different persons.
Three accused.
Three accused persons. Other 3 accused persons.
In
my
this
lord.
case,
In this case, yes, my lord. The BLPL number 420/2024. BLPL number.
Right down.
Four- Yes, my lord.
All are assigned to this bench?
Yes, my lord. And my lord,
Next week.
my prayer, my lord, it may be kindly listed in any first day of weekly, my lord.
Good week, next week for all the 3
First
months.
day.
And see, the money transaction is about 50.
My lord, not only here, my lord, throughout the country, my lord, by giving the false service, my lord, there are crores of rupees has been. This particular, Surat Dali was the cook, my lord, and he has taken 6 lakhs from this state. Probably, let us come.
ଏଟା ବଡ ଜିନିଷଟା ଆପଣ କହିଦେଲେ ତା ନାଁରେ ଏଲିଗେସନ ଅଛି।
No, what I have been instructed by the IOM, sir.
It is
just let me
well organized crime or a simpliciter one incident crime.
କିଏ କ୍ରାଇମ କଲା that's a different issue।
24
ଏଇ ପିଲାଟା ହେଲା ଓଡିଆ ପିଲାଟେ all are ସାଉଥ
No, no,
ଇଣ୍ଡିଆନ
no.
ଯୋଉ ଚାକିରି କରି ଯାଇଛନ୍ତି ଇଏ ତା ପାଖରେ ଅଛି cook।
ଇଏ ରୁଷିଆ ଥିଲା।
ସେମାନେ କଣ ଏଇ ଯୋଉ ଗ୍ରୁପଟେ ଅଛନ୍ତି ସେମାନେ ସବୁ ଆସିଛନ୍ତି ତା ଓନର ମାନେ ସବୁ ଆସିକି ରହିଛନ୍ତି ଭୁବନେଶ୍ୱର ରହିଲା ଭିତରେ ଏ ଫ୍ଲେଡ୍ ଆୱେ ଏଇ ଯୋଉ ପିଲାଟି ଦିସ୍ ପର୍ସନ ତାର ରୋଷେଇ କରେ ଘରେ କାମ ଦାମ କରେ ତା ଅଫିସରେ this person and 2 others ଗୋଟେ ତା ପାଖରେ କାମ କରୁ 3 ଜଣ ଯାକ ଏମାନେ ଆସି ପୋଲିସ ଯେତେବେଳେ ଆଇଛନ୍ତି ପଳେଇଛନ୍ତି ଏମାନେ କାଗଜ ପତ୍ର କାହିଁ ଦିଅ ୟାକୁ ଧରି ଆଣିକି ଏଣ୍ଟାୟାର କେସଟା ଆଙ୍କ ମୁଣ୍ଡରେ ଖାପିଦେଲେ ସେମାନେ ସିମ୍ପଲି ଯୋଉମାନେ କରିଛନ୍ତି ସେ ସବୁ ଚାଲିଗଲେ ସେ କମ୍ପାନୀ this person is cook ରେକର୍ଡ କଲା ଏକା
This generally happens because the pressure from outside.
Yes, ma'am.
And these एमन थिले भी involved भी थिले एमाने they might have taken a very
Few
small
money.
ଆଜ୍ଞା ଚାଷୀ ସବୁ ଲେଖିଛନ୍ତି ଯେ ସେମାନେ ସବୁ ହେଇଗଲା ଏମାନେ ମିଳିମିଶି ସବୁ କରିଦେଲେ ଯୋଉମାନେ କମ୍ପାନୀ ସେ ଚାଲିଗଲେ
huge money against the other accused persons. And this person having only 7 lakhs. In his
7 lakhs, 51,000.
Yes.
Record ଟା ଅଛି
Acha. Let us verify.
One with if we study next Tuesday Wednesday. ସବୁ ଜାଗା ଲଗେଇ ଦିଅ।
ଡେଟ୍ କାଇଣ୍ଡଲି ଡେଟ୍
Date within 15 days I'll finish it. Don't worry.
ସେ 8 ମାସ ହେଲାଣି ରହିଲେଣି ୟା କଣ୍ଡିସନ କଣ ଭାରି ପେଥେରିକ ନା ସେ ଜାଣିଛି କିଛି ନାହିଁ କିଛି ବୁଝିପାରୁନି ବଇକି ଜେଲ ଭିତରେ କୁକ ବୋଲି ଜାଣିଛନ୍ତି ତାଙ୍କର ସେ ରହିକି ବସି
when your bail application is rejected by the way
not by the lower court ଆଜ୍ଞା it was on
2/3/2024
ଆଜ୍ଞା
thereafter the charge sheet is filed
ଆଜ୍ଞା
you should have gone to trial court
ଆଜ୍ଞା
you should go
ଆଉ ନେଇ ଲାଭ ନାହିଁ ଡେରି ସେ ଯାକୁ ଫେର ଆସିବୁ ତ ଗଲାଣି
I'll send the other main accused person to trial court and I'll consider your plea. 25
Offense under section 302. I'm in custody, my lord, 8/10/2023, my lord. 8/10/2023.
What are the allegations against you?
Occurrence, my lord, 3/10/2023.
Yes. CD come. CD.
Yes, my lord. CD.
And in this case, my lord, my name is not in the FIR, my lord.
Maybe. Charge sheet.
Charge sheet is filed, my lord.
What are the allegations against him?
Allegation
Manoj Kumar.
only for the suspected ground, my lord, the present petitioner is implicated on the confessional statement, my lord. There is no other
Yes.
allegation against
my
me,
lord.
my lord.
My lord, that is the motive of my lord, keeping the illicit relationship with one married woman who has been whose
Geeta
statement
Mahanti.
yes, whose
Geeta
statement
Mahanti.
has been deposited on 164 my lord. That ମୋର ସ୍ୱାମୀ ବିଶାଖାପାଟଣା ରହିବାରେ କାମ କରନ୍ତି ମନୋଜ ସାହୁଙ୍କ ସହିତ ମୋ ସ୍ୱାମୀଙ୍କର ବହୁତ ପୁରୁଣା ଦିନର ସମ୍ପର୍କ ଦିସ୍ ପିଟିସନ ସ୍ୱାମୀ ଘରେ ନ ରହୁଥିବାରୁ ତାଙ୍କ ସହିତ ମୋର ଶାରୀରିକ ସମ୍ପର୍କ ମଧ୍ୟ ରହୁଥିଲା ସୁଶୀଲ ଆଲିଆସ ଲିଟୁ ଆମ ଗାଁର ପିଲା ସେ ମଧ୍ୟ ଆମ ଘରକୁ ଯିବା ଆସିବା କରେ ତା ସହିତ ମଧ୍ୟ ମୋର ଶାରୀରିକ ସମ୍ପର୍କ ଥିଲା ମୁଁ ମନା କରିବା ପରେ ମଧ୍ୟ ସେ ମଦ ପିଇ ସେ ମୋ ସହିତ ସମ୍ପର୍କ ରଖିବାକୁ ବାଧ୍ୟ କରେ
Litu.
ଦିସ୍ ଇଜ ମାଇ ଲର୍ଡ ଗତ 3/10/23 ସନ୍ଧ୍ୟାବେଳେ ପ୍ରଥମେ ମନୋଜ ସାହୁ ଆମ ଘରକୁ ଆସିଥିଲା ଏବଂ ସେ ପଳାଇଗଲା ତାପରେ ସୁଶୀଲ ଆମ ଘରକୁ ଆସିଲା ସେ ପିଲାଙ୍କ ସହିତ ହସଖୁସି କରି ପଳାଇଲା ତା ପରଦିନ 4:10 ସକାଳୁ ସୁଶୀଲ ଆଲିଆସ ଲୁଟିକୁ କିଏ ଚାଳିଆ ଘର ପାଖରେ ମାରି ଦେଇଛି ବୋଲି ଅନ୍ୟମାନଙ୍କ ଠାରୁ ମୁଁ ଶୁଣିବାକୁ ପାଇଲି ମାଇ ଲର୍ଡ ଆଇ ଏମ୍ ସେଇଂ ମାଇ ଲର୍ଡ ଆଣ୍ଡ supporting to this 161 of the statement of a post occurrence, my lord. Just a relevant point, my lord. ଗୀତା ମାହାନ୍ତିଙ୍କର ସ୍ୱାମୀ ଦୁର୍ଯ୍ୟୋଧନ ମହାନ୍ତି ବିଶାଖାପାଟଣା ରହି କାମ କରନ୍ତି ସେ ଗଲା ପରେ ମନୋଜ ସାହୁ ତାଙ୍କ ଘରେ ଦେଖାଶୁଣା କରନ୍ତି ତାଙ୍କ ଘରକୁ ପ୍ରାୟ ଯିବା ଆସିବା କରନ୍ତି ମନୋଜ କୁମାର ସାହୁଙ୍କ ସହିତ ଗୀତା ମହାନ୍ତିଙ୍କର ଅନୈତିକ ସମ୍ପର୍କ ଅଛି ବୋଲି ମୁଁ ଜାଣେ ମୁଁ ଗାଁ ଲୋକଠାରୁ ମଧ୍ୟ ଶୁଣିଥିଲି ପ୍ରାୟ 8:30 ସମୟରେ ଲିଟୁ ମହାନ୍ତି ତାର ମୋଟର ସାଇକେଲରେ ଗୀତା ମହାନ୍ତିଙ୍କର ଘର ପାଖକୁ ଆସିଲା ଦିସ୍ ଇଜ ମାଇ ଲର୍ଡ ଓ ମନୋଜ ସାହୁ ତାଙ୍କ ଘର ଭିତରେ ବସିଥିବାର ଦେଖି ଘର ଭିତରକୁ ନ ଆସି ମୋ ଡ୍ରେସ୍ ଦୋକାନରେ ବସିଥିଲା କିଛି ସମୟ ପରେ ମନୋଜ ସାହୁ ତାଙ୍କ ଘରକୁ ଗଲା ପରେ ମୋର ସାଙ୍ଗ ସୁଶୀଲ ମହାନ୍ତିଙ୍କ ଘରକୁ ଗଲା କିଛି ସମୟ ପରେ ମୁଁ ମୋର ଦୋକାନ ବନ୍ଦ କରି ଘରକୁ ଗଲି ଯିବା ସମୟରେ ଦେଖିଲି ଲିଟୁ ମହାନ୍ତି ଗୀତା ମହାନ୍ତିଙ୍କ ଘର ଭିତରେ ଥିଲା ତାର ପରଦିନ ଶୁଣିଲି ଯେ ମର୍ଡର ବୋଲି ଆଣ୍ଡ ଦି 127 statement my lord of the accused my lord leading to discovery with the weapon my lord.
There is nothing substantial.
Your lordship, may it please your lordship. I am for the complainant, your lordship. The complainant is the father of deceased, my lord.
Husband.
Rajiv Mahanti is the complainant, the
father of deceased.
Husband is what is the statement of husband of this Gita? He is not witness.
At the time of incident, he was in outside.
One of
the story comes like this. This Manoj had a relationship with this lady. And the other guy was also having a relation with that lady. Merely because they both of them are having a relationship and he was he died or whatever.
That has been admitted by that 164 statement of that women, my lord. both have illicit relationship with me.
That's there.
Yes.
That part is admitted.
My lord.
But for the death of the other paramour of this lady, what are the connecting evidence?
There is nothing, no connecting evidence. As for the record is concerned, my lord.
That is the confession
How do you
manual leading to
establish it?
discovery. This
Last scene is also will not help because the last he has seen there in the
is
shop.
the shop owner.
Shop
and
owner.
Yes, my lord.
That is also not there. What is recovery? What have you recovered?
The recovery, my lord, the weapon, my lord.
That is the
My lord,
recovery is the
gotte
You are in custody since 8 10, no?
8.
iron grass cutting bill hook, koturi, jar lumber, so and so, and answer. This has been said by this petitioner, my lord.
That is in the ashram, my lord.
Disclosure.
Undisclosed.
That's the problem.
Your Lordship,
Have you
Your Lordship, in this case,
verified
please file charge sheet.
No, nothing.
Regarding
No scientific evidence. How will you proceed? Nothing.
Your Lordship, in this case, police filed preliminary charge sheet and the investigation is going on, my lord. In the meantime, the complainant filed one 1cc case, complaint case, that is protest petition.
Still investigation is going on.
Yes, my lord.
Yes, my lord.
After adjourn it for 2
I'm
weeks.
yes, my lord.
He is entitled for bail. I'll tell you. If you don't, in the further investigation, you don't bring anything, then I'll enlarge him on bail.
Yes, my lord.
Let it be 202, whatever.
Yes, I may obtain the up-to-date CD and
Yes.
26. Fix a date. Oblige.
Yes, 26.
26, my lord, 376, 376 2N and 6 of the POSCO Act.
Read 164. Custody since?
164 statement is there and
Custody.
custody since 2/1/24.
124.
Charge sheet already filed, my lord.
Yes, what
My
is
lord,
the
my lord.
Medical report does not support the allegation and
24.
My
Yes,
lord,
24.
I'm
Girl-
sorry to
girl
mention,
age?
my lord. Notice has been, this is a matter of 376(3), my lord. Earlier notice has been served, my lord, but regarding this sufficient or not, so your lordship may will please to kindly
You are
give
appealing?
another chance.
appeal করছেন তো?
Yes, yes. he is
Come, let
yes,
us.
Yes.
CD is available and 164 statement is also available.
Log affairs.
Yes. 14 is available.
14, but he is also 24 young.
ଭଲ ପାଉଛି କହିକି ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲେ ବାହା ହେବେ ବୋଲି କହିଲେ ଏହା ହେଉଛି allegation consist.
This
married person, my lord.
Having with the child.
he is a married person.
Yes, my lord. Having with child also.
That is a problem for you. I generally grant bail for the young people. Age difference is not much and all. You are married and you knew this fact.
That is correct, my lord. But present petitioner is also 24 years. Present petitioner is 24 years.
Let
Are they tribal people, my lord?
let this victim be examined.
I will take instruction because
After 2 weeks. Victim is examined? In the court?
for example.
So after 2 weeks. After 2 weeks. Yes, sir.
27 already acquitted.
Charge
Already framed. Charge framed.
Charge has been framed. Let us see. Try if the victim can be examined. At least we can consider. 27. Disclosure.
27 already acquitted.
Yes.
376 POSCO already acquitted.
28.
My lord, another may I pray, my lord, one thing. My lord, item number 41. The brief has been already transferred from me. My name may be deleted. 41.
41.
Satyaj acquitted.
Acquitted.
41.
My lord.
28. Offense?
My lord, offense 376 A, B, my lord, and 6 POXO, my lord. Investigation is open, my lord. Victim is only 6 years, my lord.
6
And
years?
Only 6 years. And 164 statement is also.
Since 16/5/2023.
Charge sheet, what happened?
Charge sheet, my lord, submitted. Charge sheet submitted on 12/9/23. Under section 302 120B 34 against the present petitioner. Though it are brutally murdered, my lord,
Yeah, the accused were identified by means of CCTV footage. But the present role of the present petitioner is that, my lord, he has only given information regarding the movement of the deceased. Other 3 persons killed. They were involved, they were killed. Some leading to discovery, some weapons was seized. And the present petitioner and his friend, other 3 friends, they only given the information to the principal accused, these 3 accused, regarding the movement of the deceased.
On his version, I have been
On
implicated.
his information, the accused person.
What was the motive?
My lord?
Motive.
My lord, motive.
Motive is relatable to this accused, or motive is relatable
No,
to someone?
No, my lord. That is relating to some other accused. That principal accused Prakash.
3 accused, who all are the 3 accused?
My lord, they are Prakash, Prashant, and
Prakash
Sibo, and Sanatan.
Prashant?
Sanatan.
Sanatan.
My lord.
Okay. These are the 3 people, those who have committed the crime.
Committed the crime.
And he has given the information regarding the movement.
Kalia Sahu, Ramo Raul, and Rahul Ponda. Rahul Ponda is the present petition. This petitioner by in a motorcycle, they have followed the deceased and they have given information regarding the movement of the deceased.
What is the motive? $120B is there.
120B is there.
What is the evidence 120B? Have they conspired before the commission of crime and decided to kill? Anything of that sort?
No, that is not there, my lord.
That I have not checked, my lord.
Intention.
That,
Whether there was an intention to kill or not. If the intention to kill, thereafter if they are aiding to the main accused, then the problem. If there is no intention, he's following. Who knows? These people might have given the information, but they didn't know that they'll kill or what.
They have been implicated on the statement of the co-accused that Prashant, my lord.
First, my lord,
Confessional statement of Prakash Khatua, I have been implicated.
Footage is you found the footage.
CCTV footage. Prakash was there.
No, what about this Kalia?
That I will check, my lord. 120. Due to my lord, actually.
Confession re amu implication
Next week
karcha.
he is entitled to pay. If
My
you
lord.
can't entitled. Next.
Actually, my lord, due to late receipt of this file.
I know, that is the reason I am accommodating. You just read it. Just see connecting thing. If he has a knowledge that they are going to.
No. There is no knowledge.
Let him see.
One Pradeep Sahu is in custody, my lord. He conspired in the jail to kill the husband of the informant, my lord. There is a instruction to.
Let him.
Yes.
I will check. Yes. Entirely, I have, my lord, I have not verified it. I'll only overlook that the files.
Because late you might have got the files.
But there is some problem in our office. Therefore, yesterday we have received
change of guards and this happened.
some advocates clerk, they were removed from the service. For that reason, my lord, this file was reached in our home at 11:30, 11:45.
This will happen for.
So in the morning, I have just overlooked that file, but I have not gone into deep of the.
Okay, just read 1 week. Therefore, I'm accommodating for 1 week. No problem. Yes.
Madam, offense under section
304, my lord, CD requirement. 302.
Annexure 2, your lordship, 164 statement. Custody since 25/12/23. Charge sheet submitted 15/12/24. 164 statement, your lordship, kindly see. Both were known to each other. When the aunt C, no,
24.
23 वर्ष आगे. ये 24 वर्ष पुआ, 23 वर्ष झियो.
They were in relationship.
Yes, my
Show me.
lord. That is the 164 statement.
Read it.
ମୁଁ ଆଜି 26/12/2023 ରିକରେ ଉପସ୍ଥିତ ରହି ଏଇ ଭଗବାନ ଶୁଭ ଦେଉଅଛି ଯେ yes my lord.
ଆମର ଚିନ୍ତାମଣି ଜାନି ତାଙ୍କ ଘରେ କାମ କରିବା ପାଇଁ ମତେ ଡାକିଥିଲା। ମୁଁ ସେଠି କାମ କରୁଥିବା ସମୟରେ ବହୁତ ଥର ଚିନ୍ତାମଣି ମୋ ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ମତେ ରେପ୍ କରିଥିଲା। ଅନ୍ୟ ଲୋକମାନେ କାମ କରି ବାହାରିଲା ପରେ ସେ ମତେ
If he is only disable of speaking and not, you are getting away.
She stated in 164 regularly with the boy, my lord. He is a 24, he is 23.
Mentally retarded girl, maybe
And,
you might be taking in. She 164. She doesn't say that I have a love relationship or anything.
କାମ କରିବାକୁ ଯାଏ
କାମ
regularly.
କରିବା যায় doesn't mean that he is
And
working in a relationship.
other have stated,
I
my lord,
only want to see whether you have taken advantage of the
that
her, disability or not. If you have not taken, it is somehow consensual, then you are getting paid. Yes.
37.
next week, my lord.
Next week, you get a report.
On the next Friday.
Friday. No, 1 week.
1 week after.
Friday. Next week will be very, Friday is working day, yes. 16th is working day.
Yes, ma'am. 16.
Jam pay. Anyway, ठीक है.
57 and let's say on behalf of Mr. Basperid, I'm praying for a short adjournment because in fact.
Adjourn.
39, 2 weeks after.
Adjourn.
40.
On behalf of dear Mr. kindly pass over.
Pass over.
Pass.
41.
But you want my lord that Mr. Mishra, he has stated that the file was transferred from him.
Name to be deleted, na? Name to be deleted, then what is the case? What APS? Name to be deleted, na? Mr. Rajit Mishra, name to be deleted.
41 that 3762 and 3 SCST and 6 post.
When the charge sheet was filed?
And CD has not come. CD has not come. Notice was also not issued. The noting is that due to non-filing of requisite, notice was not issued. And earlier, your lordship, that this Hon'Ble court has directed it to serve a copy.
No,
the notice would be
on 4/12/2023. This his bail application rejected, isn't it? And he should revive the bail plea in the change circumstance. Mr. Rajit Mishra, land counsel for the land counsel who was appearing for the petitioner has withdrawn his Mokalatnama due to lack of instruction from his client. I have perused the record. It appears 4/12/2023, the bail plea of the petitioner is rejected. After the petitioner rejected also, rejected. Since the bail plea was rejected long back, and investigation has already proceeded, and the changing circumstances, the petitioner shall renew his bail application before the trial court. Before the trial court. With this observation, the petition is disposed of. I'll just come.
जो क्यों 37 38
The matter may be taken on any other day. Adjourn. Yes.
43.
On instruction, your lordship, petitioner has not surrendered.
Sorry, I'm so sorry.
Petitioner is one on bail, interim bail, my lord. Till date, my lord, he has not surrendered, my lord, on instruction.
By which order the interim order was given granted?
He 424, my lord. 3/4/2024, your lordship.
Interim bail? Dated?
Yes, your lordship.
When was the interim bail granted?
43, he has not filed the surrender certificate.
No, bail.
43.
Interim bail, when the interim bail was granted?
Interim bail was granted on 8/5/24.
8/5/24,
my lord.
No. This is item 43, na? Do you have any idea interim bail, when interim bail was granted? What is coming?
That date was not
complete blank.
8/5/24 order is not there.
Nothing is there. You must tell me when the interim.
Lordship, let it come next week.
No. First of all, you don't surrender, and next week you don't know when the interim bail was granted. These are small thing expected from you to, assess the court.
An offense is 3762N, so it cannot be compromised. ma'am.
It comes for the petitioner submits that this court admitted the petitioner on interim bail. However, the petitioner has not surrendered as yet. When the matter was taken up on 16/7/2024, the petitioner has sought 10 days time to ensure that the petitioner who was released on interim bail should surrender. However, today, when the matter is taken up, then counsel for the petitioner submit that the petitioner has not surrendered as yet. In view thereafter, the present petition seeking the regular bail is rejected, and the trial court is directed to issue appropriate process for ensuring this balance in the court. Yes, next. 44.
Yeah, please, my lord. My lord, offense under section 341, 448, 354, 354A, 354B, 376.
But don't keep on reading sections. Tell me. 354, main section is 354A.
354A, 376.
Custodians?
2224.
Huh?
2224.
2224. Yes. Allegation.
May I please, my lord? We have kindly have relance to the affair, my lord.
Tell me the allegation.
Allegation, my lord.
I have filed power minor.
You are for?
I have filed fiction. I have filed my bill of power minor.
He is appearing for whom?
Yeah, earlier advocate minor.
Not the power available, my lord.
You have given no objection to him.
Yes, power I have filed.
You decide who will argue. I am not interested. You decide. Whoever assists me, I
Minor, they are giving consent minor. I have filed the
They are living on consent.
Yes, minor.
Sir,
Yes.
lordship, मुझे सर जानने से senior नाहंती से
One minute. They are living together now. That's what he says. Huh?
No.
Living together, no.
No.
What do you say then? Said living together. He is in custody.
I am talking about the power minor. Case which case
Show me, tell me what
My
are the
lord,
allegations
here,
on this.
my lord, rejection order was on 29/2/24. And charge sheet submitted on 33/2024. So you
Okay,
may
354, what are the allegations?
My lord, I am reading that
It is made out with grant bail. Yes.
376 was not.
Not 376, 354.
My lord, ଯେ ମୁଁ ଘରେ ଦିନ 2ଟା ବେଳେ ଘରେ ଭାତ ବାଢୁଥିବା ବେଳେ ମୋ ଘରେ ମୋର ଦୁଇ ପୁଅ କେହି ନଥିଲେ ଏଇ ସମୟରେ ଆମ ସାହିର
My lord, the order passed by the learned third additional session judge rejecting my prayer for modification of the bail condition.
What
Well,
the condition? Which condition?
Condition was that, my lord, to pay rupees 18 lakhs to the informant. That was the
Show me where is the condition. Where is that?
My lord,
My lord,
and
that
this
is-
is the order, my lord, that 12, my lord. Page 12, my lord, second part, my lord.
Yes.
I'm reading the perusal of the case record. So also the investigation, my lord, got it.
Yes.
On the report, it is found that rupees 29,67,000 has been paid by the informant in different account of the accused petitioner. The seizure list reveals that PAN card and Aadhaar card issued by the government of India in the name of Patrick, the present petitioner. Laptop have been seized from the possession of the accused. Then, my lord, the law and counsel for the petitioner submitted a memo of undertaking to the effect that the petitioner is agreed to 15 lakhs to informant.
Yes,
And-
my lord, that is what.
That is what
Yes,
I am
my
also
lord.
asking you.
And your
How
lordship
to get
also.
out? It is not a direction of the court. It is your undertaking. Then
Lord, may pass orders on merit. Because-
you are relying upon the Supreme Court.
My lord,
They come to the Supreme Court judgment.
my lord.
What does it say? Dilip Singh.
Page 21, my lord, the judgment starts.
Relevant part you read.
My lord, page 22.
Hmm.
By imposing the condition of deposit of rupees 14 lakhs, the High Court has in an application for pre-arrest
So
bail.
this is the imposition of condition.
My
It
lord.
is not imposition. You have given the
undertaking to the court. Right. Petitioner is agreed by the condition, bail condition imposed. Where is that? Petitioner is agreed by the order dated 13/7/2023, whereby although the petitioner has been enlarged on bail, but with the condition that he shall deposit 18 lakh rupees. Return 18 lakh rupees to the informant. He puts up the petitioner is agreed by the said condition. The related counsel for the petitioner has relied upon the judge of Supreme Court passed in criminal appeal number 53 of 2021, Dilip Singh versus State of Madhya Pradesh, and submits that imposition of condition which are onerous in nature while granting bail is not permissible under law. I have perused the judgment as well as the impugn order. From the impugn order, it is it reveals that the condition is not imposed by the trial court while granting the petitioner on bail. Rather, the petitioner who has undertaken to deposit, undertaken to return the 18 lakh rupees to the informant. Therefore, the trial court has only recorded his undertaking and accordingly enlarged the petitioner on bail. Since from his own volition, the petitioner has offered to deposit offered to return the amount to the informant. He cannot be his case cannot be covered by the judgment. His case is completely distinguishable from the judgment cited by the petitioner. Hence, I am not inclined to entertain this petition. Yes.
47.
Please, are you going to pay on installment?
No, my lord, he is not in a position to pay that.
47.
47, I am there virtually, my lords.
Yes, sir.
Lords, here.
Not on behalf of Mr. Maharana, he is held up in court number 3.
Passover.
After
He's asking for Passover, Mr. Maharana.
Passover. Maharana is court number 3.
Yes, Passover.
After lunch, then.
Yes,
after lunch.
Yes,
May I please your lordship? This is a case of Belgium. On 21/12/2022, the NBW has been issued against me. And due to no steps.
How many of you are there? Right on. Petitioner is agreed by the order dated 24/12/2022.
21/12/2022.
21/12/2022. Whereby the court of who? Which court is this? Court of Sessions first term. ADJ. First ADJ Sambalpur has issued the NBW against the prisoner for his absence from the court. On the instruction of the instruction, Land Counsel for the petitioner on the instruction from his client submit that he would be appearing on or before 31st of September. August. You appear, oblique surrender before the court and seek remedy available regarding head to the submission made at the bar. The NBW issued against the petitioner by the order dated 21/12/2022 by the first ADJ Sambalpur shall be kept, execution of NBW shall be kept in event till 31st of August 2020, subject to the petitioner surrendering before the appearing before the court below and availing a remedy under law. With a petitioner is also cost of rupees 500. Can you hear me?
Sir. Lordship, I can.
Cost of rupees 500 to be deposited
Yes, Lordship.
before, yes, allowed.
49 is also, my Lordships, 49 is also same matter.
Same করে 49 भी same. ठीक है. But the one one why was it listed item?
That matter that Mr. Dharaj to enlighten us about the.
Oh, okay. Yes. 2 o'clock we'll do it.
Okay.
Exact 2 o'clock. It may take time. Exact 2 o'clock. Have you got hold of anything? Got some idea? Then we'll do it.
Well.
It is already heard.
Well,
It's already heard.
No.
While dictating, I got stuck in
that's
a
core
particular-
ballot I have to alert.
2 o'clock exactly.
Well.
First item, and 2 o'clock. Item 50. Yes.
50 below not press.
Not
The
press.
liberty to file better application.
Bail, na?
No. CLMs.
Petition seeks to withdraw the petition to file a better one. Dismiss it.
Oblige.
This would not be issued due to non-filing of the requisites. It was listed on 31st/7/2024.
Sorry, sir.
My lord, before lordship on 31st/7/2024.
Uh-huh.
As per direction of your lordships, I had filed the requisites on 1/8/2020. 1/8.
Service complete. Not sufficient. Waiting.
On subject.
Complete. Service complete. So I'll put it service complete. Let us see. He may come. Service on the respondent number 2. 2, na?
2, yes.
Respondent number 2 is complete, but there is no appearance on behalf of the said respondent. In the interest of justice, release the matter.
Interim order is there.
Interim order to continue. 52.
May I please, your lordship, may I permitted to appear to virtual mode. Lordship, in the present case,
Yes.
filed a IA for a change of nomenclature. The present case pertains to special act. Hence, the registry may be directed
What should be the nomenclature? It should be appeal.
CRLA. Yes, your lordship.
It should be an appeal, huh?
Yes, your lordship. CRLA.
Is it so?
Yes.
Yeah? And once it will be appeal, it will go to the concerned assigned bench.
Yes. Yes, your lordship.
The application is
Please
allowed.
set appropriate bench, your lordship.
Nomenclature is changed to CRLA and release the matter before the assigned bench. Yes.
Bless you.
53.
May it please, lordship, I prefer an adjournment also.
Adjourn.
Obvious.
Yes. 54.
I am for the full petition.
Yes.
Lordship had referred the matter to the mediation center.
Yes. What happened? Mediation.
Is a report in the lordship.
You tell me whether successful or fail.
My lord, 2 sittings are passed, my lord. The matter is all again, my lord, posted. Mediation.
Oh, the mediation is still, the matter was referred to mediation, and mediation is still going on. Least after 2 weeks. Yes. 55.
May it please this for further, Cognizance has been taken under section 436 IPC. The Honorable Court may kindly see, may I just play the impugned order, page 11.
Yes.
May I please? Page 11.
Notice.
May I place?
Notice insufficient. Let's see. देखो तो. Notice is insufficient.
Notice तो हमें comply कर दीचु जीवो पुनी दे दीचु सब नहीं जाई नहीं
Postal stamp is lack of postal stamp.
नहीं second थरो जाई नहीं first थरो जाई फेरी आस्तला second time उठाना we have complied, we have given deficiency.
Second time also deficiency.
Yes.
And we have complied, that we have deposited.
Huh? Sorry?
Noting
2 weeks or 3 weeks कर देना.
interim order may continue.
Interim order to continue. Yes.
56, the defects will be removed within a week. My lord.
Many defects you are not removing.
Yes, there are so many because the defect number 6 has already removed because that AG copy has already.
December 2023 you filed, not removing the defect. Why are you serious about this matter?
My
I
lord.
don't think you are serious. What is this matter is about?
Matter. Question.
Passing of what?
No, question of interim order by the annexer 9.
What is this order?
Order
For the investigation.
reinvestigation
Reinvestigation, Lordship. Which is
under section 173(8).
Who are you?
I'm the
you are the complainant.
complainant, my lord. Yes.
Reinvestigation for what? Charge sheet is filed.
Charge sheet is filed.
After CRL also displayed, again it is referred to that again by which judgment he is referred to, that is also dealt. And
I don't think you have a case. You have other remedies. You know what remedy you have. That's the reason likely you are taking this matter.
No, my lord. This should be the last chance for
You
removal of
don't have a
defect.
case, so what to do? You have filed it. So
Give me 3-4 days only. My lord, let it.
okay, 2 working days, huh?
Not a problem.
Within 2 working days, defects are not cured, the same shall be dismissed without reference to.
3 days. 3 days, my lord.
3 days, okay, 3 days. And once it is filed, then leach it up.
Obligation. Good.
57. 57. That's the 2011 matter. I thought. Yes.
Petitioner has filed this.
Oh, that doctor thing you said.
Appellant has filed this appeal against the judgment dated 23/11/2011.
My lords, before that, can I submit something else? The small matters can be completed so that this can be taken up after
That's
2
good
p.m.
idea.
Yes.
Let me run through the list.
Yes, my lords.
Leisurely I can.
I have no objection to that.
And let me run through. Run through the list.
Yes. After lunch at 2
Yeah.
p.m. No. No, before lunch, we adha
No, before lunch it may not
It
be
is not
possible.
possible.
Come, relax. Even if it reaches,
No, I am totally relaxed for this.
No, why should you wait? You can have your own.
At 2 p.m.
58, 2:30. You come 2:30. Another matter I have kept it.
Oh, all right.
58.
My lord, this is an application 391 filed by the learned counsel for the appellant. I had already filed the objection yesterday only. This is an application under section 391 for additional evidence.
Counsel for who is the counsel? Huh?
I have already filed the objection yesterday only and copy has been sought, my lord. And there are allegations, they are, you are also trying to have a glance to the prayer. It is a prayer. Prayer person may kindly do that.
Yes.
She wants to call for the guard file. And it continues from the page, your lordship may kindly have a glance to page 2 bottom of the petition.
Page 2.
Page 2 of the application, that the vigilance case, it appears that there has been allegations, but that during or tenure, the following allegations.
Where are you reading? Where are you reading? I am not able to.
Page 2 of the
IA petition.
IA 1859.
1859.
Page 2, para 4. The vigilance case, it appears that there has been allegations that during or tenure, the following allegations were made to the effect that money had been paid to the same persons. However, no corresponding receipts were available on record. However, it is necessary to state here that all the receipts are present in the guard file, oblique cash register. And the following people, as per allegation of 28 of the judgment, have also signed after receipt of the payment. Your lordship may kindly, this number 1, Devaraj Paigo, has been examined as PW 14. Your lordship may kindly have a glance to the evidence of PW 14 before we take it there.
Yes, what is
page 105? Your lordship will be satisfied.
105?
105.
Yes.
Your lordship, I know Sushma Singh and Khodika Badanayak, who were executive officer and sarpanch of Labor Singh respectively. I was the ward member by then. I never get any remuneration for attending the meeting. Even I was not supplied with tiffin or expenses for the same. Cross-examination. The meeting was held once in every month. Auditor was working as surplus for about 1.5 years. It is not a fact that I have received any remuneration for attending the meeting and that I am deposing falsehood. Your Lordship will peruse this receipt has been enclosed along with this application at page 12. Running page 12 of the IA application. This sorry, my page 9.
Yes.
Running page 9.
Devraj bhai.
Devraj, your Lordship the kind of
Yes.
He has not received anything else in his evidence he adduces. Number 2. Your Lordship.
And why there is so big gap between the contents and the
Receipts have
signature?
been filed by them. I am placing before your Lordship. Number 2. Your
Why
Lordship.
there is a gap?
My lords, that I don't know, my lords. What?
That means it was procured earlier and it is thereafter.
My lords, my entire case is what my friend is saying is, my lords, they have deposed in court that they have not received. But there are receipts showing that they have received these amounts.
But this receipt from the naked eye, it
My lord.
appears to be manipulated.
My lord, this is what has been
Created.
given, that is what has been granted by the authorities. Now, I was an executive officer, for roughly 3 months. Now, these are the receipts which are there in the guard file. For example, my lords, he says he denies that I have not received anything. If he had the opportunity, it was my lawyer's fault, my lords. I admit that. I have said inadvertently, I have used a euphemism, my lords, to soften the blow. But actually, it was the lawyer's fault. They never called for this record and they did not confront. If they would have confronted, notwithstanding this receipt, they would have said, this is a fraudulent receipt. This has not been signed by me. Then I understand, my lords, whatever the consequences. What she is saying, my lord, what the client is saying, my lords, is that all the receipts were present. I had informed our lawyer that all the receipts were present. He never called for these receipts and never confronted the.
You show me in the entire evidence.
Yes, my lord.
Wherever you created the existence of this.
My lords, they have not said anything about it. My lords,
The witness has come and say that no, I have not received. Even if these receipts are there, neither here nor there.
But my lords, if the receipts are there, my lords, the purpose of 391, my lords, 391 has been incorporated.
See, the problem is if the documents are brought on record today,
my lord,
and the prosecution will lose the opportunity to confront.
No, my
with
lord.
the same witness who has said that I have not received anything.
But my lords, it will.
Then I have to retrial everything.
My lords,
This aspect, I will satisfy your lordship. To the evidence of the IO, your lordship will be satisfied.
My lords,
Suppose I bring it. So it's okay.
My lord.
And I apply the application.
My lord.
If I bring it, whether the prosecution has the right to
cross-examine, my lords.
Then I'm entering to area where retrial.
Retrial, my lords, my entire stand before your lordship is, I'm trying to get those documents also by RTI. We have applied under RTI that these receipts are there. And the very purpose of 391 is to see that, my lords, I'm just reading out from Zahir Abdullah versus where the lordships in the apex court had discussed the concept of 391, why it has been introduced. The legislative intent in enacting 391 appears to be the empowerment of the appellate court to see that justice is done between the prosecutor and the persons prosecuted. And if the appellate court finds that certain evidence is necessary in order to enable it to give a correct and proper finding, it would be justified in taking action under 391. My lords, thereafter they say, there is no restriction in the wording of 391 either as to the nature of the evidence or that is to be taken for the prosecution only, or that the provisions of the sections are only to be invoked.
Hey, there are two situations. If an independent evidence is there, I can very well bring out on record and try. But if you are trying to bring an evidence on record,
my lords,
which will nullify the testimony of the witnesses, those who have come and said that yes, I have
they
not
will,
received, in that situation, what will happen?
In that situation, they will have the opportunity to cross-examine.
Then.
But
Actually,
that's
set
very 12.
aside
That's,
the judgment, bring that on record and ask them to.
Malas, I am giving you lordships just one example. Let us say there is an allegation against, like here, my lords, let's say an allegation against an officer that 5 lakhs she has expended, he or she has expended on some particular amount. And there are receipts. Now, because of the carelessness of the trial court lawyer, these receipts have not been brought on record. And the person who has given the receipts squarely denies them. Does she not have a right to confront these documents to the person who has denied it? My lords, I understand.
One situation, if you say after the judgment was filed,
yes,
I discovered this document. Is one situation.
Imbalance.
Second situation is these documents were there, but my lawyer has not done it. This is another situation.
This is the situation
So
here.
the second situation, you have to face it because your lawyer has done it. You have
my lords, I cannot say that I was not unaware of these documents. I was aware of it.
After the judgment, I can take it.
What my client says is that she has instructed her lawyers to call for these documents, but he has never called for these documents to confront it to the people who are now disputing that we have never received any payment.
Show me whether you ask the IO that Haji, why he is not.
No cross-examination in that line, my lords. My lords, I understand, my lords. My lords, I cannot go beyond what has been said in the trial court. But 391, I am only invoking your lordship's conscience. See that an innocent, if at all there is something, I'm just reading out.
Get me some judgment then.
My lords, here the prime. I'll give you a lordship.
There. I'll tell you. See, the idea of the trial is to go to the right conclusion.
Yes, ma'am.
Right conclusion. This is the whole idea of the criminal.
Exactly.
If something has happened, you have to see that the right thing should come to the light so that guilt or no guilt can be proved. So you are trying to say that wrong reason, whatever reasons.
Yes.
The documents were there, it's not placed on record. So therefore, I can invoke this provision at this. Show me any judgment where it says that irrespective of whatever, if some document come to the forefront, even at the appellate stage, the court can take into consideration to meet up in subjustice.
My lords,
show me direct judgment, I'll allow it.
Yes,
send
I'm just reading one line also. The primary object of 391 is the prevention of a guilty man's escape through some careless or ignorant proceedings before a case or vindication of an innocent person wrongfully accused. So I'll come within the second scope. I'll place the judgment
It
later
will
on.
also help to some extent.
To some extent. And
what,
Miss,
you think look into it also. We can. I'm not going to acute or something. If these documents are brought on record, if he satisfy me, then in that case, you will get opportunity to cross them. And,
on that score, I have filed one decision. You also can have a glance.
Judgment.
Para 18. I have just given it.
Judgment.
AIR 2011 Supreme Court 1363.
He gave the judgment and he is reading something else. I am searching what where he reading. Okay. 89 marked it, but I thought where.
No.
1370.
Yes, I read it. In view of the above, the law on the point can be summarized.
Point can be summarized to the effect that additional evidence can be taken at the appellate stage in exceptional circumstances to remove an irregularity where the circumstances so warrant in public interest. Generally, such power is exercised to have formal proof of the documents, etc., just to meet the ends of justice. However, the provisions of Section 399 cannot be passed into service in order in the prosecution's case. So your lordship will find the
no, that's the difference. That's the whole difference. Prosecution cannot be given leverage in so far as 391 is concerned. When it comes to accused, the situation is reverse. Because we are testing the innocence of the person. Prosecution can't fill up the lacuna by employing 391.
No,
but if it is otherwise, if the accused can fill it up.
Yes, your lordship is correct.
That's the difference is in a higher pedestal.
Exactly.
It says that prosecution cannot be given opportunity under 391 to fill up the lacunas.
But above.
But it is the reverse situation. The accused is asking.
But it should be exercised in exceptional
Yes,
circumstances.
That is always there.
So your lordship may kindly have a glance to next only to
Why,
satisfy.
why this is there is because the presumption of innocence in favor of the accused has excused after he is convicted. Therefore, the appellate court should be very careful about it.
Yeah.
That is the law.
Exactly.
But in the same time, the judgment which you are reading, it goes in their favor in true sense.
No, exceptional circumstances I rely.
But last line, Jesse.
Yes. In
Scope shall not be given to the prosecution to fill up the lacuna.
They had the enough opportunity to call for those documents, but did not call for those documents either or proved the same. Rather, they have filed these documents, out of which your lordship will be astonished. Page 12 of the running page may kindly be filled. This I running page 12. Your lordship will be satisfied.
12, yes.
Running page 12, this document.
Yes, I have seen this.
This document in words and figures.
Likhita Rashid.
Likhita Rashid 35,000 your lordship amount may receive.
Yes.
And this person has been examined. Receipt is
And
this.
therefore, I saw, see, the page is also the receipt. Just see why there is a gap in between. That means it was manipulated also.
No, this receipt.
ନା ଏଇ receipt ରେ ନାଇଁ 12 page ରେ 9 ଟାରେ gap ଅଛି
9 ଟାରେ gap ଅଛି କାହିଁକି gap ରହିଲା
ସେଟା ମୁଁ କହି ପାରିବିନି ଆଜ୍ଞା ସେ
gap just see such a big page in this much is written receipt at the end it is signed and there is a blank.
My lord may kindly see this receipt is not tallying with his evidence in page 99. In page 99 may kindly be paper page 99.
Yes.
The lordship will be satisfied. In last paragraph itself.
Yes.
In the year 2006, I got to work out.
I received 40,000.
10, 20, 10.
Yes.
On 286, I received further 21,000. I also received 10,000. Where are those receipts?
Rajendra Kumar.
Rajendra Kumar, where are those?
ସେଇଟା ପାଇଁ ତ ଆଜ୍ଞା ଆମେ RTI ରେ ଗାର୍ଡ ଫାଇଲ ଟା ମଗେଇଛୁ
Next is your lordship may kindly see paper book page 85.
85.
He is PW2. His name is Bhaskar Chandra Sahu. Running page 17.
Bhaskar Naik.
Running page 17 may kindly be tell.
20, na?
This IF running page.
Yes.
And he is PW2, page 85. The evidence may.
Rajendra Sahu, Bhaskar Sahu.
Bhaskar or not? Bhaskar.
Yes.
I know accused Sushma Singh, who was the VLW come executive officer of that Gamma Panchayat Kodika Bondak, the Sarpanch has also taken my signature on a paper for construction work.
Sometime I feel if there is no defense counsel, they will be acquitted.
Mal.
Sometimes if you don't have a defense counsel, they will be acquitted. See, conviction is only because of defense counsel.
She has not paid any amount to me. Such work for such work.
See, these documents were there, they should have confronted this document.
That is exactly my case, that all the my lords, I am getting
the witnesses is coming in the witness box is telling something else contrary to the document.
Contrary to the document, and that cannot happen.
And you would have confronted with them. And
my lords, I am asking your lordships 4 weeks. This matter live.
But I'll decide the legal issue for the benefit of
my lords. Before deciding the legal issue, I want 4 weeks time so that I can place all the documents under the RTI before your lordship. We have the guard file will be provided to us through the RTI. Then if your lordships feel that it is not necessary for these documents to be gone into, then
necessary or not necessary is one thing, but I want to issue, I want to decide the legal issue.
391, then my lordships will keep it to another date. I'll get other judgments.
What is happening to this case? I am interested to decide the legal issue so that
my lord,
the law is in the right perspective.
Certainly, my lord.
And we'll apply that law in this case also.
Yes, my lord. Yes, my lord.
One line.
One fact, you have a very strong case. I'm still.
No.
One fact, but in the law,
running page 20.
22.
Of the IA. Running page 20.
Yes. Yes.
This date may kindly be, I am giving importance to the date. ଘରଭଡ଼ା ବାବଦରେ 1000 ଟଙ୍କା ପାଇଲି 23/9/2006
2006.
ରଜନୀକାନ୍ତ ପଟ୍ଟନାୟକ
He is Rajanikanta Patnaik, Kishore Patnaik.
ରଜନୀକାନ୍ତ ପଟ୍ଟନାୟକ so Narasimha kindly have a glance to paper book page 100.
100.
I have given the date madam 23/9/2006 paper book page 100. This Rajanikanta Patnaik has been examined as 11.
Yes.
Second sentence. On 15/8/2006
I received 1000.
towards husband. So which received, which evidence is correct or this received is correct?
That is what you have to
Your
confirm.
answer is to this. He was the, my lord, she was the.
This maybe you are correct. These receipts might have been manipulated and introduced
Exactly.
also.
Exactly, my lord,
That
because
can't be ruled out.
my lord,
I'm not saying
executive officer from
the-
DLW.
The veracity.
It is supposed
Oh, just 1
to
minute. Let me
enter
speak now. You
all the
don't go on
receipts.
interrupting when I'm speaking. You're just going on interrupting. What is this?
Yes.
Well, the veracity of the documents can be tested only when there is a fresh trial. If at all
If at all the application is allowed.
if at all the application is allowed.
But it can't be ruled out the fact that he might have inserted all these things.
Manipulated. If
It
your
may not
lordship
be
feel-
available at the time of trial. This might be a situation.
My-
You never know.
My lord.
Get RTI information.
Yes, well, RTI I'll get, and the law, if your lordship wants to decide, we can
I'll
take it up
decide
week
it.
after next.
I'll decide it.
Yes, well.
After 3 weeks, you release it.
Yes.
Yes.
Yes. After me.
3 weeks.
3 weeks. Sorry.
No, don't.
I generally don't.
Generally, you don't do that. I also watching at you.
So that's why he's a close friend of mine.
Then this sorry will not help you now. Now you have to do something.
I have to give him another.
What happens?
But you have to do something else now. Now, honest is in you. How will you satisfy him? Yes.
Obliged, well. I'm also sorry for losing.
Solid. This happens sometimes.
Sometimes.
59 Lordship, I'm praying for a Passover, Lordship.
Passover.
Lordship, kindly allow me to page number the documents that have been filed,
Yes.
written notes and.
ନାଇଁ ସେ ପାସ୍ ଓଭର ନ ହଉ ସେଟା ଯଦି ହବ ମଣ୍ଡେ ଆସୁ କିନ୍ତୁ ପାସ୍ ଓଭର ଆଇ ହାଭ୍ ଅଛି ଅନ୍ୟ କୋର୍ଟରେ ଲଞ୍ଚ ପରେ
Is a problem.
Lordship, the interim order is there.
No,
You
interim-
continue?
ଆଉ ସୋମବାର ଆସୁ
Obliged.
I have filed the objection. I have filed in the e-filing counter.
हाँ,
The
objection.
soft copy I have filed.
Objection नहीं है record.
Objection and the decision may be kept on record.
But you find out, Mr. Das, you find out some other.
Yes, 391.
391. It's a good question. Yes.
May it please, my lords.
Yes, sir.
Extremely limited point. 3 documents I'll show to your lordship, my lords. Lordship may kindly.
This is for what? Passing.
What? The facts are extremely, my lords, in a limited.
Cognizance.
Cognizance.
Yes.
Basing on a supplementary charge sheet.
Yes.
In the preliminary charge sheet, my name was not there. My name surfaces for the first time.
Yes.
In the supplementary charge sheet. My lords, your lordship may kindly turn to annexure 2. That is at page 29.
Sanction.
To the superintendent, this is by the additional SP vigilance. This is a communication to the government. Supply of information regarding refusal of sanction by the order by the government. Enclosed, please find copy of the GA department letter number so and so, where government has been pleased to decline sanction of prosecution against this suspect officer, so and so. Against in vigilance case number PS case number 29 of 28/5/2010. As Director Vigilance requires, list of such pending cases where government has refused sanction of prosecution against accused officers may kindly be furnished much prior to the director's review meeting on so and so. Then the next page, 30. To the Special Secretary, Government GA Vigilance Department, This is on 25th October 2016.
Yes.
Sanction of prosecution against Sri Sudhanshu Shekhar Bhuiya, OS officer, at present land officer, GA department. I'll just take a break. One of the most honest officers I have worked under. And I have worked in quite a few of these special engagement in GA departments in land matters. You're not sure. I have quite some sufficient experience. So, personally, I'm quite convinced about this. Sir, I am directed to invite reference to your office letter number so-and-so on the subject mentioned above and to say that the government has been pleased to decline sanction of prosecution against the suspect officer, Shri Sudhanshu Shekhar Bhuiya, OS officer, BDO, so-and-so, at present land officer, GA department in Bhubaneswar Vigilance PS case number so-and-so, and orders have been passed for initiation of regular disciplinary departmental action against Shri Bhuiya under OS under department OCS, CCS rules.
So departmental proceeding is suggested instead of giving sanction.
Sanction is not there. Now, my lords, this was my lord, next year Lordship Council impugned order annexure 3.
Yes.
7/12/2017. This letter was issued, the earlier letter refusing sanction was on 25th October 2016. Post that, so therefore, thereafter, charge sheet was filed, my name was excluded. A supplementary charge sheet comes in, no new materials, my lords, and my name surfaces in the supplement. And this it's
and cognizance is taken on that.
Writ large on the face of it. One, received the supplementary charge sheet number 36 of 17/11/2007, Vigilance PS case number so-and-so. Under section 13(2), read with 13(1)D PC Act and section 120B against the accused person, namely Sudhanshu Shekhar Bhuiya, Amiya Kumar Das, Atma Charan Singh, Bhupati Bhushan Mohanty. I am only for this one. It is seen from the charge sheet. Number 51, read with so-and-so, was received against the accused person, namely Amiya Das, Atma Charan Singh, Bhupati Mohanty, and cognizance was taken by the order dated 21/8/2017. Peruse the FIR, supplementary charge sheet, and other connected materials available on record against accused Sudhanshu Shekhar Bhuiya. The materials available in record previously makes out a case for alleged offence under 13(2), read with 13(1)D.
Earlier cognizance was taken against
the other three persons, Amiya Das, Atma Charan.
already taken, long back.
Already taken.
21/8/2017.
So this is a limited point, man. If the sanction has been denied, so man, the prosecution is to fail. You can't, the cognizance order is to go. Now, what remains under 13(2), 13 read with 13(1), that is all gone.
Yes, Mr. Mohan.
Only on 120B, if the predicate offense goes, the conspiracy part also goes. Automatic, my lords. That's the only point.
Yes.
The only issue is
Cognizance
whether
without sanction.
No. Sanction was sought for under section 19 in respect of PC Act. No sanction is required in respect of 120B, that is IPC offences. So we have not sought for sanction under section IPC offences. So now cognizance sanction was refused under section 19. Law is well settled. Despite refusal of sanction under the PC Act, IPC offences can be proceeded. So now the question is whether 120B
What is the cognizance order? What
cognizance so far as cognizance order is concerned, cognizance
13(1)(2).
But I'm coming to that. I'm coming to that. I'm coming to that. So far, they along with the present petitioner, other accused persons are there. So far, we humbly admit that section 13(1)D will not be attracted because we will go because of this lack of sanction. And so far as 120B is concerned, he has to face trial under section 120B is an independent offense. On that was the issue before the earlier bench, and I have cited decisions whether 120B is an independent offense or not. Your Lordship kindly see that. Para 5.
Stand alone.
Yes, because other co-accused persons are there. What is the law? Your Lordship kindly see page 5, page 4, para 5 of my notes.
I'll set aside it and won't argue with trial.
My lord?
I'll set aside it and go and argue before because the cognizance order is wrong.
नहीं ମୁଁ କହୁଛି so far as
You
cognizance
argue that part you are. That open.
କୋଉଟା
120B is independently made out of.
that is decided by the Honorable Apex Court.
But see, the cognizance is taken on 13.2,
That
13.3,
120
and 120B.
other accused persons are there along with all that is the
See, I am testing the cognizance order. The cognizance order is wrong. If you can argue and I leave it open to argue on the fresh cognizance. Insofar as 120, because I am not here.
Your Lordship,
I am not in charge stage. I can't say that this is made out of that. If the cognizance order is wrong,
your Lordship is saying that you will remit it back.
Repeat it.
Your Lordship.
Pass it and go on. Okay. Right.
And my judgment, what I have cited.
Whatever you do, what do you do it? See, my problem is, had it been charged, I would have said 13.1 is not made out. This is made out. I could have said it is a cognizance order. Cognizance order and toto I have to see.
Everything
the
is
cognizance order is wrong.
I agree. No, so far as legal issue is concerned,
you argue that
120B, whether a person can be proceeded under section 120B or not.
Setting aside, leaving it open, you won't argue whether 120B is made out. Made out without the substantive offense. If 120 is made out, he will be again.
Standalone offense, if it survives.
Again, let it be.
Your Lordship may observe that.
That's, I'll pass the order. Give it.
Good.
Because I'll simply say that cognizance order is bad, but Mr. Maharana is arguing like this. So therefore, the trial court should apply mind afresh.
Well.
And decide.
Much obliged.
Whatever. So you also won the other.
Grateful, man.
You have judgment if you want to cite, you give me.
नहीं मैं सब जगह दे ही इसे कोर्ट कर दीजिए
कर दिया I'll pass it.
हमें कल जजमेंट दे दो फंडामेंटल इशू
आउ जो आउ
फंडामेंटल इशू I
सेटा तो सेट जाओ सेटी तो अलग गोटे लाइन है
let them argue. You get one more opportunity to come.
One more, not opportunity with jocular everything.
It's this personally, madam, this is one of the most honest officers.
I know the department says that what happened to departmental proceeding?
It's dropped.
That is also dropped.
Now I will face 120B.
And
Mr. Maharana's grant
departmental
of
proceeding
jurisprudence.
suggested by the sanctioning authority. Also dropped.
And Mr. Maharana's grant of jurisprudence may not I'll face.
नहीं ମୁଁ judgment ଦେଇଛି referring to that judgment my lord justice chief justice has also even supreme court judgment I have given then chief justice has also passed an order.
Whatever you argue I'll set aside. You argue whatever you
Preposterous question.
I was thinking that it should prolong till evening. You have done it right now.
What I have done.
No, evening pacification is better.
Evening pacification would have been far better than he is ill-advised. No, he is ill-advised.
नहीं से सबु बेले बड़ पार्टी करंती तेनु फर्स्ट टाइम के तो तांग पार्टी गला तेनु
Grateful.
Part out matters, my lords. All the counsels for the petitioners are ready, my lords. I am also ready. May I pray, my lord, after this few short matters, Mr. Dhawan will address your lordship. My senior Mr. Panda will address with short matters. And this matter, part of taken at 2:45, so that I will get time to place all this.
Yes.
2:45.
2:45, no? Okay. Meanwhile, I'll Exhaust the board.
Not
He'll
just
take it as-
2-3 matters. There, short matters.
Item one. Yes. Then we will find them. Then
And the question was,
what was the two? Same. Two is also same. Yes.
just to, we are not on facts value. Point of law, when we,
Right.
that has crop up with the last time. But Prevention of Corruption Act. Was its origin to 1947. First act is 47.
Okay.
Act 2 of 1947.
Old Act.
Old Act.
Old Act.
And it was amended, so to say, a sea change has been made.
88.
88. Then it has been amended in the year 2018. Initially, the parent act, 1947, the penal section was section 5.
Okay.
Which is criminal misconduct in discharge of official duty. There, my letter C, subsection 1 is a public servant is said to commit the offense of criminal misconduct. Under 1, A, B, C, D, E is there. We are not on that.
Right.
Whether we have conduct, misconduct is there. Or not. In 2, any public servant who commits criminal misconduct shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 7 years, also be liable to fine.
Right.
There a proviso has been added, provided that the court may, for any special reason recorded in writing, impose a sentence of imprisonment of less than 1 year.
Yes.
So this proviso was there under subsection 2.
Yes.
And in 88 Act, that provision, that penal provision is section 7 and 13.
Parametry.
Parametry, not parametry, same language has not been used. But penal section is 7 and
13. Okay.
7 and 13, where they have increased the sentence.
To 7
I'm not saying what is the maximum sentence, which, to how far it can be extended, because we are not on that now. But this proviso which was there in 47 Act,
it's taken off.
Has been
done away with.
Yes. It is not there in 88 or 2018.
Right.
So question now comes up. There is no minimum sentence. The term minimum sentence has been defined in many places by the Apex Court. But here, in view of the proviso, there is no term called minimum sentence.
Right.
Because court can, by assigning special reasons in writing, can impose sentence which is less than 1 year. It may be
Anything.
It may be rising of the court like this.
Anything.
Well, and then comes up, if this proviso is there, whether Provision of Offenders Act has got application. That question was also raised on that day. Well,
But what about these offences? These offences are 88 Act or 47 Act?
47.
47 Act.
47.
Okay.
All the old cases are on 47. 2018. 18 ballot, only section 7 and
Right.
13.
This is 5. This is 5, huh?
This is 5. All the cases are on 5.
5.
Now all the old matters will come where sentence is on section 5 of Prevention of Corruption Act.
40.
We are lucky today because Mr. Pandai has already left. Because he has a good number of cases.
No, there is one doubt here. Just come to 5. section 5.
My lord.
2, 5(2).
My lord.
Where we are stuck is which last Jesse, which may extend to 7 years and shall also be liable for fine.
Yes.
Okay.
Yes.
But this proviso is relatable to the first part or second part?
Only sentence.
So then
Fine
the
is
7
must.
years can be reduced to any sentence.
Yes.
And along with that fine.
Fine is a must.
Fine.
That has been considered. I have brought judgments also on that. My lord, question comes up, whether applicability of POI. My lord, relevant provisions on the Prevention of Offenders Act are 4, 5, 6.
Provisions of offenders. POI. Section? Section 4.
Yes. These are the relevant provisions, but I'm not putting the same because that has got no relevance for our case. Section 4 deals with power of court to release certain offenders and provision of good conduct. That is not our case. 6 is also restrictions on imprisonment of offenders under 21 years of age. That is also not applicable. Here, section 18,
18. Yes.
Section 18 is a bar to deal with. I have considered in that way, but I do.
Saving operation of certain.
Nothing in this act shall affect the provisions of section 31 of the Reformatory Schools Act 1897 or subsection 2 of section 5 of Prevention of Corruption Act.
Direct bar. Leaving apart the judgments, obviously, because of this 18 bar.
So when
so that part is ruled out.
That part is completely ruled
completely
out. I should not argue something and which will be detrimental. Yes.
Yes.
Because that has been construed. Exactly, section 18 has not been referred. Let me see judgment.
But there is a statutory bar, even if in the there is a statutory bar. So we may not lever on judgments.
No,
There is a
I'm
bar,
not,
there is a bar.
I'm not on that. With regards to the proviso part.
Proviso to 47. 47.
Yes. This is the only judgment I got, wherein though section 5 has not been construed, parametric provision, not exactly parametric, that is a penal provision wherein a proviso is attached that 498.
Yes.
498. It's a case of 498. Dealing with a case under 498A, Honorable Justice Deepak Mishra has hold in that night.
Yes.
Valid. Therein, Court was pleased to release the accused, Delhi High Court was pleased to release the accused under section 360.
Yes.
But while going to analyze section 360, let me see from paragraph 2 onwards, how the court has observed. The respondent challenged the judgment of conviction and order of sentence before the learned session judge Unano, UP, in criminal appeal number. So we, in course of hearing,
You are reading BG Goswami.
I am reading, my lord. That is Muhammad Hasim versus State of UP. BG Goswami.
Hasim.
Muhammad Hasim.
ठीक, yes. First,
my lord.
Yes.
Being aggrieved. Paragraph 3, my lord.
Being aggrieved.
Being aggrieved by the aforesaid judgment of the learned appellate court, the informant referred criminal division number so and so before the High Court. In its nutshell, the counsel for the informant placed reliance on several so and so and state of so and so to buttress the submission. The benefit under PO Act could not have been extended to the convicts regarding her to the nature of the offences, and the High Court is legally reasonable. In this court, it is pertinent to appreciate the scheme of PO Act under section 3 of PO Act confers power to the court to release certain offenders after admonition. The state provisions reads as follows. Section 3, 4, 6 has been quoted.
Yes.
We may note here that the appellate court has exercised the power under section 4 of the PO Act. It is submitted by the learned counsel for the appellant that as the respondents were convicted under section 498A and section 4 of the 1961 Act, the respondents could not have been right for section 4 of 1961 Act prescribes a minimum sentence. Additionally, beneath the said provisions applicable, the court has not considered the nature of offences and other repeated aspects to extend the benefit under the state provision. We shall deal with the first aspect, that is whether section 4 of 61 Act prescribes a minimum sentence. First, the Samlal Soberma, so and so 2 judge bench, after referring to Ratanlal Arora, has held. It is not in dispute that the issue raised in this appeal has been considered by this court in state versus Ratanlal Arora, wherein in similar circumstances, this court held that since section 7 as well as section 13 of Prevention of Corruption Act provides a minimum sentence of 6 months and 1 year, respectively, in addition to the maximum sentence as well as imposition of fine. In such circumstances, clearly it has been specific. The Suppression of Immoral Traffic in Women's and Girls Act in 56, Act 104 of 1956, and 4, of any law in force in any state relating to juvenile offenders or hostel schools which prescribe the minimum sentence. And so stating, the court further proceeded to state that they have quoted paragraph 7 of Bahubali's case. It is profitable to state here that the court referred to the decision of Arvind Mohan Sinha, wherein it has been held, Bahubali's case, that the broad principle that punishment must be proportional to the offence is or ought to be universal application, save where the statute bars the exercise of judicial discretion, either in awarding punishment or releasing an offender on probation in lieu of sentencing him for 3. That is applicable to 88 in 2089. If once the court will reach at a conclusion, prosecution has proved to its case beyond all reasonable doubt, then minimum sentence 3 years, that is to be imposed. The court cannot go beyond that. So at this juncture, we must state the promptitude that the 3-judge bench in Bahubali opined that the applicability of the PO Act, as has been held in Arvind Mohan Sinha, could not be taken aid of inasmuch as attention of the court was not seen to have been invited. The said case to Section 43 of Defence of India Act. Section 43 of Defence of India Act is like a parametric provision of Section 28 of Prevention of Corruption Act.
This judgment has widened the scope of Section
48 says the act that it should not be in inconsistent with the other provisions. Which was not there in 47 Act.
Long and short of the matter is, even if a minimum sentence is given, if the court feels it appropriate, Section 4 can be applied. That's the take of this judgment.
No. Application of 4 is not there. With regards to other offences, it is there. But with regards to prevention of corruption,
It's not there.
it's
It is
a
ruled
specific
out.
bar.
It is the specific bar.
But the way minority is disposed of 379. With a lesser ramification.
Those things
can be done. But here, statutory bar is there, Section 18. So prevention of corruption, the case of the prevention of corruption cannot be stopped.
It's completely open.
So here,
One more problem is, so what I do, suppose for example, funding. And for mine, I have to have it for the sentence. For sentence, can't exceed the social sentence. Someday, I mean, what will be If you are the default of the fine, it is not come back. Can I simply say that the fine is 1,000? That is it.
To send the appellant back in jail now after 7 years of the agony and harassment of these proceedings, when he is also going to lose his job and to earn a living for himself and for his family members. And for those dependent on him, we feel that it would meet the ends of justice if he reduced the sentence of imprisonment to that already undergone, but increase the sentence
200 to 400.
200 to 400.
Without default.
Period of the imprisonment in case of default will remain the same. For the next
The
case,
period of imprisonment in the case of default will remain the same.
that remain the same. But in the next case, that is 87.2 SEC,
Then the sentence is increased, the fine is increased, but the default sentence is remain same. That's what. But there is a default sentence. There is a default sentence. For 200, whatever the default sentence was there,
but
for 400 will also.
but in the next case, pilot will see at page 25, flag C,
Yes.
para 13.
Yes.
We therefore affirm the conviction of the appellant for section 5(1)D, Radial section 5(2) of the Prevention of Corruption Act, and also under section 161 of the Code, IPC. In view, however, of the fact that about 6 years have passed from the date of the incident, and this is the first time the appellant has committed an offense, we reduce the sentence to the period already undergone by the appellant. The sentence of fine is, however, sustained. No.
Fine along with the default.
Similar is the view in 95, volume 5 SSC 320.
Yeah, fine upheld means the that goes along with the default. Default.
Here also, my lord, in page 29, relying upon B.G. Goswami, they have also, B.G. Goswami is the other 74th judgment.
Right.
The paragraph 8, page 29. Now coming to the question of sentence, it is a very old case, and the occurrence itself is said to have taken place in the year 1979. All these years, the accused has undergone the agony of criminal proceedings. He has lost his job, and we are told he lost family to support. In similar circumstances, in B.G. Goswami, so the sentence of imprisonment was reduced to the period already undergone. From the records, it appears the appellant was in jail for some time. Accordingly, while confirming the conviction, we reduce the sentence of imprisonment to the period already undergone. The sentence of fine with default clause is, however, maintained. Fine with default clause, perhaps they have referred to the judgment, madam.
Default is must. Default sentence is must.
Next panel, the Delhi High Court judgment. They have relied upon the 95 Supreme Court, this thought. Here, madam, no fine has been imposed in Delhi High Court. Pilot received
Only sentence. That's wrong.
I have wrong.
That's completely. That's against the statute.
Because pilot asked me on in one of the occasions that you find out some decision of any High Court, whether the High Court can exercise this power for that. High Court.
This is wrong. Delhi High Court is wrong.
Delhi High Court had asked to give the must.
And fine is must, and default sentence is also must. That is the third.
Else, pilot,
and that default sentence should not exceed the substance.
On this score, whether
And there are judgments also. Suppose 1 year sentence is there for 5,000 for penalty. There you can't say that in default he has to undergo 1 year. And it is commensurate with the substantive. That's the law.
Yes.
1/4.
And 30 of CRP.
30. Yes. 1/4.
whether we will see distance on that.
So suppose I'll say TRC.
Mental
1/4 of what? Yes.
But the mental agony and the period, long pendency of the case are not a ground. So far as the consideration of a reduction of sentences is concerned,
that is a ground to consistently the courts are taking. That is the only ground.
That's the only ground.
से ground रे करा जाय पारिबनी बोली PC Act रे अछि. That judgment also. जदि मते मु जानि नथिल also. अछि. Apply against to.
Don't add to the problem.
My Lord Justice Sierdas has also delivered a judgment reducing that period undergone.
Period undergone, understand. There is no period.
Aguru nothila.
That is the problem. 47 Act, the people used to get the
Tier 1 re chhadi dothile setore.
Same day.
That's the problem. Yes.
other judgments are there also of the apex court. So, Kali Amro conclusion is that we should not commit any wrong.
No, we can't.
That section
So-
18 is a bar. Go ahead.
So now you tell me in the first case, that is appeal number 168 of 2001.
104 of 96.
Huh?
Appeal number 104 of 96. Item
104,
1.
where is- give 104.
Kailash Chandramurthy.
Do you have any material so we can acquit? So on merit matter.
Concentrate on acquittal.
Yes, that I was interested.
Because we were thinking that we will not go into, because looking into going to
Yes,
his
yes.
age, he is about 95.
So I may take up this matter on 14th, 2 p.m.
If you have material, you
Yeah,
tell
good-
me.
good materials are there
And
for
then we
acquittals.
will think of acquitting this. That's the only way.
That's a better way. 85 years old, huh?
If at all acquittal is possible.
22nd, madam. And audit says 22nd.
Or if you say, if you
Let me argue
suggest
on-
me if I can
let me
reduce
argue
the
on-
reduce the sentence to about 3-4 days sentence.
My lord, what my lord and friend submitted on the last occasion, police visited his house and found him completely bedridden. And I am interested. to argue
One-
the
one
case-
of- one of
I mean,
the-
to case- and his son is a lawyer in Raipur. So he crying, oh, my father is 84
Yeah.
years, 95 years. I got it.
Which one? You are talking about 10168.
104.
104.
Item 1. ma'am.
The other case, my lord, that Telugu.
Krishna Rao.
Krishna Rao, his whereabouts is not known.
Not
Might it be impose 5 days sentence, 4 days sentence?
That I can do. That I can do. I'll
Because
reduce the sentence.
they have tried, I have tried.
And he will die, but take him to that. That I'll do. Huh?
And the-
I-
and the-
so I'll allow this one petition, huh?
And
By
this-
reducing sentence to Kailash Chandramurthy, na? Kailash Mudili.
Item.
No. Krishna
No, no.
Rao.
Krishna Rao. And the second is Sam,
No.
67. His whereabouts is also not known.
Whose?
Item 67. 67. ma'am.
The same problem.
Same
Old
problem.
Act.
Old Act.
67.
But Muduli, I will argue.
And in 67 and
2. Item 2.
And
Yes, that is
67 Krishna
item
Rao,
2.
sentence minimum sentence like kar diyo, minimum sentence 1 week or something I'll do and finish it up, both the things. Okay? Or in so far as Mudili, Kailash Mudili is concerned, we will concentrate on acquitting him. Some material is there, then we'll
अच्छी अच्छी
material is there.
मैंने खलास हुआ फिर
For 2 reasons, forget off the record, 2 reasons. He is about 95 years. And he is the father of a lawyer. So let him die. Honorable.
peaceful at least. No, for that reason, I was ready there till the rising of the day, court or appeal order gone without mentioning anything. But that because
But
he
it's
will
not possible.
Not possible.
Not possible.
So I'll argue the case on merit.
In this first item, there is no fine imposed also. Only sentence is there.
That's wrong.
Yes.
We are in appeal.
Yes.
And trial court has committed wrong. So
Yes.
therefore, we have to correct it. And if not in the conviction and sentence part, we have to be correctly do it. This detail कर दियो, देखियो, detail कर दियो, minimum fine. I'll do it a week or so. Sentence reduced to 1 week. Huh? 1 week with fine of rupees something, 1,000 or something, and 2 days default. Okay. Symbolic. It has become symbolic.
Symbolic.
Huh? This one, Kailash Mudili, adjourn कर दिया.
Conviction.
Sir को पूछ लीजिए. 22 तारीख. ठीक है.
67 judgment reserved.
Same
Yes.
And if they have undergone any sentence, that will be taken into
That also I record.
This is आपके आगे वर्तन दीजिए.
Yes. What happened? 28.
In fact, if Lordship permits, my learned senior has put India were in fact discussed with me, my lords. But all the judgments, those are submitted notes. Another two judgments are there also, I will also.
I got the same problem is. We were trying to find out ways, but nothing. Yes. 28. What is this? 28. Hey, pass it. Offense?
376 AB.
No, 28. 28, huh?
28.
Who is there? 376.
One significant statement is there, my lord, which cannot be read out openly.
When the bail was rejected?
My lord?
The bail was rejected in 6/2/2024. Charge file when? Item 28.
Yes, my lord.
Issue 9.
Issue 9.
Yes. When charge sheet was filed?
Charge sheet, my lord.
When charge sheet?
7/01/24.
24. January 24. Charge has been framed.
No, my lord, regarding that, I am not interested. Will pass one significant statement to your lordship, my lord.
Yes.
It is very, it cannot be read openly.
But the age of this victim?
6 years.
6 years.
Only. 6 years. Very heinous act.
Right. This is agreed by the order dated 10/11/2023, whereby his bail application has been. No, tell me. Order dated 6/2/22. 6 where his bail application is rejected. Mr. Rahul, the counsel for the state, has read out the statement of the victim recorded under 164 CRPC. The allegation in the statement of the victim girl who is 6 years of 5 years of age. He was 5 years of age at the time of incident. He is very shocking and shocking. The petitioner was a 30-year-old man who has committed the serious crime. Having regard to the statement of the victim and the fact that the trial has not commenced, I'm not inclined to grant the petitioner bail. Liberty granted to the petitioner to renew his bail application after the examination of material evidence. This observation. Next. 40. Yeah.
May I please?
Yes.
Case of 302-201 by 34 IPC. 302-201 by 34.
Yes.
The
Custody.
on custody since 8/10/2021, Your Lordship. And there is no eyewitness on the basis of suspicious because previously
Custody
8/10/2021.
21.
Yes, Your Lordship.
Yes.
So far, the material available on record that except 27 Evidence Act statement under so leading to discovery, no other statement as against the petitioners. Even any of the accused, on the basis of suspicion, the case of
How many accused are there?
two accused persons.
Present
Another
petitioner,
accused person
another
is
is
released on bail.
Other accused has already been.
Released on bail.
Same rule.
This
He is the principal accused, my lord.
He is the principal.
My lord. But one, my lord, I'm reading the statement that the PM report is due to strangulation. Leading to discovery, my lord, a dead body and clothes wear of the motor vehicle. It was seized in the instant of that another accused, my lord. There is a Dhoba Malik, my lord. And present petition is the uncle of Dhoba Malik.
Uncle of?
Dhoba
The
Malik.
principal accused Dhoba Malik. Present petitioner, my lord.
Okay.
And my lord, I'm reading one statement, my lord, that Kartik Malik, my lord.
Yes.
My name is Kartik Malik, my lord. Saibani Malik, jone that disease. Godo choto bikolang thila, that disease, my. Se ante gala. 7-10-21 ରାତ୍ର 8:30 ସମୟରେ ହଠାତ୍ ଆମ ଗାଁର ଲାଇଟ୍ ଲିଭିଗଲା 10-15 ମିନିଟ୍ ପରେ ମରିଗଲି ପାଣି ଦିଅ ବୋଲି ବୁଢୀ ଲୋକର ଶବ୍ଦ ସାଇବାଣୀ ମଲ୍ଲିକର ଘର ପଛପଟୁ ଶୁଣି ଲାଇଟ୍ ମାରି that present petition has ଟର୍ଚ ମାରିଲା ସେଠି ଆମ ଗ୍ରାମର ଧୋବା ମଲ୍ଲିକ ଓ ଅନିଲ ମଲ୍ଲିକ is the present petitioner ଖଣ୍ଡା କାତି ଧରିଥିଲେ ଏ କିଏ ଲାଇଟ୍ ମାରୁଛୁ A light kahinki maruchu
he has
bond
been turned hostile. He has been examined and turned hostile.
He kahinki sunuchu boli Dhoba Malik party shabda sunili. Semane party koriba.
Supported.
That deposition copy is not with me, my lord. Whether there 7 witnesses were examined out of 17 on the date of.
And except this so-called eyewitness, what else you have?
And my circumstances that this present petitioner has seen that the one of the witnesses has seen that the present petitioner as is another principal accused. They were holding weapons. And they have given threatening that why are you.
And you in the commission of the crime, so far the case prosecution case is that a cloth were by help of a cloth were the deceased were yes.
And my
If
dead
that
body
is the fact that they were holding Khanda Kati, committing murder by clothware. This is one aspect. Another, the basis of the petition is that earlier.
Medical evidence, what medical evidence is?
Well, medical evidence is that due to strangulation.
Then eyewitnesses, you read it out. Khanda Kati.
They were holding some weapons in front of them. When the eyewitness. That is pre-occurrence.
Kill someone holding
deadly weapons.
And using something else.
But medical report is that by that motorcycle clothes wear they have killed, and it is the my lord, the dead body and the clothes wear was seized, leading to discovery in the instance of that Dhoba Malik.
Dhoba Malik has been released on bail.
Dhoba Malik had turned outside.
Yes.
No, Dhoba Malik is one of the accused.
No, sorry. The witness who had seen the occurrence. He is the only eyewitness.
He's only that. Another circumstantial, my lord, one occurrence witness that I am holding. He also. That is Ramesh Malik, my lord. I am reading that portion, my lord, relevant portion. ଏକ ମାସ ତଳେ ହଠାତ୍ ଗାଁରେ ଲାଇଟ୍ ଲିଭିଗଲା ଯେତେବେଳେ ରାତ୍ର ପାଇଁ 8 ଘଣ୍ଟା ହେଇଥିବ ହଠାତ୍ ବୁଢୀର ମରିଗଲି ପାଟି ଶୁଣାଗଲା ଗାଁ ଲୋକ ଉଠିଲେ ଧୋବା ମଲ୍ଲିକ କହୁଥିଲା ଏଠାକୁ କେହି ଆସନି ଧୋବା ମଲ୍ଲିକ was present on the spot, my lord, on that occurrence. କାହିଁକି ସେ ବୁଢୀ କଥା ଶୁଣୁଛ ନିଜ ଘରକୁ ଯାଅ ଏମାନେ ଭୟରେ ଯିଏ ଯୁଆଡକୁ ଗଲେ ସେତେବେଳକୁ ସାଇବାଣୀ ବୁଢୀ ଘର ପଛପଟୁ ପାଟି ଶୁଣିଲି ସକାଳ ହେଲା ବୁଢୀର ଘର ଦ୍ୱାର ଖୋଲା ଥିଲା ରାତିରେ ସେମାନେ ବୁଢୀକି କୁଆଡେ ନେଲେ ମୁଁ ଜାଣି ନାହିଁ ସାଇବାଣୀ ମଲ୍ଲିକର ଘର ଖୋଜାଖୋଜି କଲେ ସେ ବୁଢୀ ଆଣ୍ଠେଇ ଚାଲେ ମୋର ସନ୍ଦେହ ହେଉଛି ଧୋବା ମଲ୍ଲିକ ତାର ମାମୁଁ ଅନିଲ ମଲ୍ଲିକ ମିଶି ବୁଢୀକୁ ଡାହାଣୀ ସନ୍ଦେହ କରି ମାରିକି ପ୍ରତିଶୋଧ ନେଇଥିଲେ and charge sheet was also made under section 3 and 4 prevention of witchcraft act. And Ramesh Malik has seen all are the pre-occurrence witnesses.
How many?
70.
7 witnesses were examined out of 17.
Out of 7.
Out of 17, my lord.
Custody period is.
Custody is
8/10/2021.
8/10/21. Rejection order of 25/1/2024. Rejection order
21.
25/1/2024. In the meantime, how many witnesses were examined, whether he
This
was,
bail application was
Ramesh was
37.
examined or
What
not?
we do is, I'll give 6 months time to conclude it.
My lord, kindly
If
see,
it doesn't-
whatever my lord had submitted before lordship, everything was against Doba Malik. He's on bail. Long back. It is also observed in the order of the learned session judge.
Why
Your
not?
lordship, page 15.
15.
Yes, 15, 1/5. Hard from both the sides. On scrutiny, the documents on record prima facie is suggestive about the involvement present accused. The involvement of the accused apparent from the statement of the accused on 27 Evidence Act.
The statement of the
No doubt,
witnesses.
page 16, no doubt the co-accused has already been granted bail, but the present accused does not stand on the same footing because he was absconder, he was not cooperating the trial. This is the allegation for rejecting the present
He was
petition.
been absconding.
He was absconder.
Now he's in custody.
Now he's in custody.
NBW
Custody
has
about 3.
the strength of NBW was arrested, and these are the materials.
Petition reject. The allegation against the petitioner is the petitioner is in custody since 8/10/2021. Out of how many witnesses?
17 witnesses.
17.
17.
Out of 17 witnesses, about how many witnesses were examined?
7 witnesses were examined as on 25/1/24.
7 witnesses were examined as on. Mr. Mishra and State Council has read out the evidence of the statement of the eyewitnesses recorded under 161 here. The eyewitness, who is that eyewitness?
That Kartika Malik.
Kartika Malik. PW?
7, I think 6 or 7.
Kartika Malik.
Six, 8. The copy टा भी करने रखी नहीं पाखर.
6.
6.
Keshav Malik.
Kartik what else?
Where is Kartik? Yes, Kartik. Yes. Eyewitness. पूरा sentence पढ़ो. Eyewitness Kartik Malik. Eyewitnesses stated that when the petitioner and when the principal accused, what is the name?
Doba Malik.
Doba Malik.
And the present petitioner were attacking the deceased. He in the midnight he put the torch on. At that point in time, he saw both the accused persons holding holding Honda
Kati.
Honda invaded Honda and Kati trying to attack the deceased lady, expecting that she is a weak, he is indulging in witchcraft, however, the medical evidence indicates that the deceased has died due to strangulation. That apart, the said eyewitness has already been examined as PW7. PW7. He has not supported the prosecution for the returned hostile. Apart from the eyewitness evidence, there is no other evidence to directly connect with the crime. Apart from that, the principal accused, namely the
Dhavamali has already been enlarged on bail. Since the petitioner is in the custody since 8/10/2021, and the trial is still prolonging, I'm inclined to enlarge the petitioner on bail. With additional condition. Yes.
Each day posting on the date of trial.
Additional condition, every day he will appear, or additional condition. And see paragraph violation of any condition. Yes.
Please, ma'am.
Yes, sir.
Petitioner before your lordship Millards has challenged Annexure 4.
Yes.
Annexure 4 is the order of the learned special judge who has taken cognizance against petitioner who has not charge sheeted because sanction was not granted. That is apparent. Your lordship may look at page 27, Millards.
27.
7. Serial 14, so particulars of accused persons not charge sheeted. Serial number 1 is the petitioner.
Yes.
Srikanta Purush. So he has not been charge sheeted, and my lords may look at the last column of the page. Any special remarks, including reasons for not charge sheeting. The government in GA Department, Orissa, Bhubaneswar, has declined the proposal to accord sanction of prosecution against Sri so-and-so after careful consideration of the facts and circumstances case and material evidence on record, and refusal order has been issued by letter number such and such, dated 7/4/15 by officer on special duty, GA Department, Odisha, Bhubaneswar. This relates to the offences. At the top is written 13(2), read with 13(1)D PC Act, 420, 468, 471, 120B IPC. Now, my lords, despite the fact that I was not charge sheeted, and if your lordship will look at page 2 of the brief, that is the letter of the GA Department refusing sanction, the learned special judge, my lords, by the impugned order at Annexure 4, has taken cognizance. At page 32, my lords has got it.
Yes, I am there.
It is written like this, third line. After careful consideration of facts and circumstances of the case and material evidence on record, government have been pleased to decline the proposal to accord sanction of prosecution against Sri so-and-so under section 197(1) CRPC in Cuttack Vigilance PS case number such and such. Besides, as material evidence are not strong enough, government do not feel it necessary to recommend the case to the Government of India for consideration of sanction of prosecution under section 19(1) of the PC Act. So they refuse sanction under 197, refuse sanction under 19, my lords. Despite that, my lords, the learned special judge, by the impugned order at page 36.
Cover case because that order
I'm
on merit your lordship pass because
merit is what is this?
197 in clear terms, 97 and 19 was refused. Yes.
You can't prosecute a penal
Okay,
offense.
one thing your lordship may observe that this should not
strongly oppose.
ନାଇଁ ନାଇଁ ଅପୋଜ କରୁନି ମୁଁ କହୁଛି ଯେ ଏଟା ଯାଉ ତାର ଯାଉ ଆମେ ତ ଚାର୍ଜସିଟ୍ ବି ଦେଇନଥିଲୁ in refusal of sanction in clear term 97 and 19, so there is no case cognizance cannot be taken, so but it will not act in respect of other accused. This order your lordship may observe that other cases ଅଛି ସେଇଥିପାଇଁ ମୁଁ କହୁଛି କାହିଁକି ନା ସେ ଯୋଉ କେସ୍ ଦେଖଉଛନ୍ତି ସେ ଯୋଉ କେସ୍ ଦେଖଉଛନ୍ତି ବି that has been with all respect.
No, I'm returning it. I'm going on.
କାହିଁକି ନା without hearing me.
Why should I see the?
Yes, your lordship need not. Your lordship can express, your lordship can allow this.
Observe that and
He's not covered by any case.
He's
He's covered by his own case.
ସେ ପଢୁଥିଲେ otherwise I could have said.
No, I can't rely upon it.
And
that
like
you have filed, you have not filed the
You are
ଆମେ ବି
indicating it.
ଆମେ ଚାର୍ଜସିଟ୍ ଦେଇନୁ ତାଙ୍କ ନାଁରେ
Cognizance,
କିନ୍ତୁ ସେଇ ଲାଇନ୍ ଟା ଅବଜର୍ଭ କରିତେ ମୁଁ ଯୋଉ-
yes, that I. Dispose of दे दिए मुझे लिखे दिए नोट कर दीजिए allowed
57.
May I please proceed?
yes sir.
It's order of judgment of conviction, my lord. At 23/11/2011, the present appeal has been preferred, my lord.
Yeah.
Before your lordship to the judgment, I am drawing your lordship's attention to the FIR filed by the complainant.
Yes.
That is in the LCR, my lord. In the FIR, it has been stated. Soft copy.
Yes. फिर भी वो दे दो
Paper book is not ready in this case. Only the appeal memo must.
He also told you.
My lordship, may I read the FIR?
Yes.
ମୁଁ ବନ ସିଂ ପିତା ସୁଦନ ସିଂ ଟିକରପଡ଼ା ଥାନା ବାରିପଦା ସଦର ଜିଲ୍ଲା ମୟୂରଭଞ୍ଜ ଲେଖି ଜଣାଅଛି କି ମୋର ପୁଅ ପ୍ରଧାନ ସିଂର ଡାହାଣ ଗୋଡ଼ ଦୁର୍ଘଟଣାରେ ଭାଙ୍ଗି ଯାଇଥିବାରୁ 9-10 ଦିନ ହେଲା ବାରିପଦା ବଡ଼ ଡାକ୍ତରଖାନାରେ ଭର୍ତ୍ତି ହୋଇ ଚିକିତ୍ସା ହେଉଛି। ଭାଙ୍ଗି ଯାଇଥିବା ଗୋଡ଼ରୁ ରକ୍ତ ବନ୍ଦ ହେଉନଥିବାରୁ ମୁଁ ଡାକ୍ତର ମହାପାତ୍ର ବାବୁଙ୍କୁ ଦେଖା କରି କହିବାରେ ଡାକ୍ତର ବାବୁ ଔଷଧ ଲେଖି ଦେଇଥିଲେ, ଯାହା ମୁଁ କିଣି ଆଣି ଦେଇଥିଲି। ତଥାପି ରକ୍ତ ବନ୍ଦ ନ ହେବାରୁ ଡାକ୍ତର ବାବୁଙ୍କୁ ଦେଖା କରି କହିଲି। ଡାକ୍ତର ବାବୁ କହିଲେ ମୋର ଫି ବାବଦକୁ 300 ଦେଲେ ତୋ ପୁଅକୁ ଭଲ କରିଦେବି। ଏହି ଯୋଗାଡ଼ ଟଙ୍କା କରିବାକୁ ଡେରି ହେବାରୁ ଡାକ୍ତର ବାବୁ ତାଙ୍କ ଟଙ୍କା ଦେବା ପାଇଁ ଖବର ମୋ ପାଖକୁ ପଠାଇଥିଲେ। ନବକଲା ଡାକ୍ତର ବାବୁଙ୍କର 300 ଟଙ୍କା, ପ୍ଲାଷ୍ଟରିଂ ବାବୁ 400 ଟଙ୍କା ନଦେଲେ ତୁମର ପ୍ଲାଷ୍ଟର ହୋଇପାରିବ ନାହିଁ। ମୋ ପାଖରେ ଯାହା ଟଙ୍କା ଥିଲା ଔଷଧ କିଣା ସରିଯାଇଛି, ମୁଁ ଯୋଗାଡ଼ କଲେ ଦେବି। That is the FIR.
So the demand is 300 rupees.
My lord.
Yes.
Thereafter, your lordship may see thereafter page 8, judgment starts. That has been stated in the page 9 of the judgment.
Yes.
Para 2.
Yes.
There it has been categorically stated, relating the facts of the case. Middle person, I am reading the same fact. Hence, your lordship,
Again.
middle person of the
Hence again the complainant.
Hence again the complainant complained of bleeding from the wound of his son to the doctor, who asked for bribe of 300 with assurance to cure his son. The complainant being poor, not arrange the demand money. Thereafter, the attendant came to told that these things. The no money, then he had no other order. That is this facts. It has been stated, my lord. Thereafter, last person, in response to that, Vaidyanath Kaur to be referred to magistrate.
Demand is made by
the doctor. The doctor has demanded.
No, directly to this attendant is asking.
No.
Or doctor.
Doctor.
Recovery was made from the attendant. Demand was made by the doctor.
Doctor, my lord. Demand was made by the doctor and recovery was made from the pocket of the attendant. And the case of the fact of the case is that the doctor has asked for the money of 700 rupees and he has taken, complainant had taken 300 rupees. And when he asked the doctor to take the money, doctor is plastering a patient. He told give it to the attendant. And at that point of time, that thereafter trap has been made and it is found from the pocket of the attendant. And in fact, there is no demand on the part of the attendant. And in this case, doctor has been acquitted. Since the recovery has been made from the pocket of the attendant has been convicted for 1 year.
You are admitting the recovery?
Yes, my lord. It cannot be. Recovery is from my pocket. And that is the case of the prosecution as well as overwhelming.
You only say that since there is no demand,
no demand.
Recovery is inconsequential.
Except
So
there is no intention to accept the bribe also.
Knowledge.
There is no knowledge about that because I have to obey the direction of the doctor. I am the attendant of
Why
the doctor.
was acquitted?
But because recovery has been made from my pocket and the complainant became hostile and he has stated so many things in this evidence, not in consistence.
Complainant also did not submit.
Yes, my lord. Your
And-
lordship may
And
see
also overhearing witness have turned hostile.
overwearing witnesses are stone hostile.
Is there, something is there?
And-
Let him complete, my lords.
My lord. Your lordship may see, and in this case, the IO has been died, he has not been examined.
I will not again.
No.
Complainant,
Complainant PW3, my lord.
PW3 hostile. And over over
PW4 matters, overhearing witness.
He has also declared hostile, and he has categorically stated the doctor has asked for the money.
right? You not examined.
My lord.
Not examined. Yes. Yes.
Well. In the judgment, it has been categorically stated about the said incident also. In
Show me the judgment how the doctor is.
my lord. It has been stated in paragraph 23 and 24.
Yes.
It starts from 22. And 24, the observation part. Therefore, page 25. Therefore, keeping in view the aforesaid analysis of facts, circumstances, and positive prosecution evidence and record regarding the acceptance of illegal gratification of rupees 300 by accused Nabokishar Jana from the complainant, I am strongly of the opinion that prosecution has successfully proved its case against accused Nabokishar Jana for the offence under section 7 of the PCA. Conversely, the prosecution failed to bring home the charges against Nabokishar Jana for the offence under section 13(2), 13(1)(d) of the PC Act. As such, accused Nabokishar Jana is found guilty for the offence under section 7 of the PC Act committed thereafter. 25. So far as the charges leveled against the accused Dr. S.K. Mahapatra is concerned, the prosecution failed to prove its case against him beyond all reasonable doubt as per findings, observation, analysis made above, for which he is not found guilty and for section offence under section and that has been dealt by the court below in paragraph 22 and 23.
Yes.
Basing on this evidence that the complainant has stated that in one hand there he has stated that doctor has demanded, and in the other hand he has stated that he has seen the doctor for the first time in the quarter, and thereafter in the cross examination he has stated that the fact that the doctor has not accepted the bribe, for that reason he has been acquitted.
Yes.
PW3 is the my lord.
Okay, that I take it.
My lord.
What are the material you tell me?
My lords. My lords, kindly come to the 313 statement of the accused. What is the defense that he has taken? Now let's hear. It's an admitted fact that demand against the present accused has not been proved due to the hostility of the PW 3 and 4, the decoy as well as the overhearing witness. Now, my lords, before that, I will
decoy is
PW 3 matters.
Complainant.
Complainant. My lords,
Three.
complainant is 3
3
and overhearing witness
4.
My lords, before that, I will just place a very short judgment, my lords, regarding that demand part.
In the absence of demand also 7 can be crushed.
Yes.
What's citation take?
I'm reading it.
No, citation.
I'm reading it out.
More citation.
It is reported in 2006 12 SCC 277 B Noha versus State of Kerala and another.
SCC?
SCC 277.
277.
Lordship may kindly come to page 280. Para 10 and 11. It's important. Lordship have it, ma'am. The sentence beginning with the evidence shows. Page 280, para 10.
What you have it, my lords?
Yes.
The evidence shows that when PW1 told the accused that he had brought the money as directed by the accused asked PW1 to take a cut and give the same to him. When it is proved that there was voluntary and conscious acceptance of money, there is no further burden cast on the prosecution to prove by direct evidence the demand or motive. It has only deduced from the facts and circumstances.
That is the law.
Yes, sir.
See, in the absence of demand also you can convict, no problem.
Yes.
But while accepting someone, he should have the knowledge of demand.
Yes,
unless minus the knowledge of demand, acceptance, simpliciter will not help.
Yes,
for the prosecution.
Admitted, madam.
The Chatelain principle is acceptance with the knowledge of demand. Either demand or knowledge of demand.
Yes. Yes.
He has not demanded, there is no doubt about it. But now the question is whether knowledge was there or not.
There not. And
having knowledge, if he accept, then
yes.
he is in.
Yes.
Without knowledge, accept, he is out.
And madam, this will be substantiated by the defense plea that he has taken.
Yes. What are the
page? Let's come to the accused statement.
Yes.
The last question. Question number 24.
Have you got anything?
What you have it?
24,
madam.
24.
Question number 24.
24, yes.
ମିଛ କଥା
ଏହା ସବୁ ମିଛ
ମିଛ
କଥା
କଥା
ଅଭିଯୋଗକାରୀ
bandage or
bandage
plaster?
let me complete please. ଅଭିଯୋଗକାରୀ bandage ଓ plaster ପାଇଁ ₹300 ଦେଇଥିଲେ. And this is his specific defense plea. That the money that was given to him, he has accepted the same in lieu of getting a plastering materials. Now let's come to the sequence of events now. Now let's come to the evidence of PW4, the overhearing witness, my lords. Para 11.
Yeah.
And this is a part of the cross-examination done by the present appellant. What you have it once?
11.
11. Cross-examination for accused Nabokishore Jena, the present appellant. Accused Nabokishore Jena was a dresser. It is not a fact that Bana Singh, he is the decoy, told me that while Sri Jena was putting plaster to some patient, at that time he gave money to Sri Jena. Now this is important. It is a fact that when me and the complainant went to the hospital at that time, Bana Singh did not have any plaster material to hand over the same to Nabokishore Jena. So he was not having any plastering materials at that time. Then, my lords, may kindly come to the evidence of PW1, the magisterial witness, what he says. Para 7. This is also a part of the cross-examination. And the defense that has been taken is that the money that he has received, consciously he has received, defense plea is that he has taken for the purpose of getting plastering materials. So how far he has established the same pursuant to presumption under section 20. What you may kindly come to para 7, madams. What you have it, madams?
Yes.
Para 7 of PW1. The sentence beginning I cannot say.
Yes.
I cannot say whether there was another quarter near the quarter of the accused doctor. I had gone inside the quarter of the accused doctor. I found the accused doctor using one of the rooms of his quarter as a clinic. I saw the accused doctor for the first time when I went inside his quarter. This is important. I saw the accused doctor plastering the leg of the son of the complainant with the help of the said peon Nabokishore, the present appellant. So there is no occasion to give the money to get the plastering materials when it has already been, the work has been carried out. Already plastering was done, and the other witness says that he has not received any plastering materials from the appellant. So the defense plea that has been taken is not inadmissible or plausible. So section 20 presumption comes up, and
what is your case? This man has himself demanded and himself has accepted. That's what you say.
As far as the demand part, it is silent on this. But then acceptance and recovery is there.
You are pitching your case to that level now.
No, my lord,
You are saying that he has asked for a plastering of the
yes,
this thing.
Yes.
Purchase plastering this thing.
which is not
That
a
is
truth.
demand.
Yes.
Not truth is a different thing.
Yes.
See, we are testing demand, not demand.
Yes,
And from this, from his testimony,
Yes.
13 testimony, this is sure that he had no knowledge that doctor has demanded.
yes,
For some other reason, he has asked for that money.
yes,
That knowledge is ruled out now.
yes.
Now you are trying to build up a new case against him.
My lords, I am on the
No, no.
factum of presumption, my lords. My lord, when presumption comes into
That
play,
has to be put. What is the prosecution story put forth against him?
yes,
Doctor demanded, he accepted.
yes,
This story put
Yes,
forth by you.
yes.
Today, by reading his 313, you are trying to say that he has accepted for something else. So then, what indirectly you are saying is the demand made by the doctor that he had no knowledge. Is it or not? He had no knowledge.
No.
Then he's out.
My lords, then how does he dispel the presumption under section 20, my
No,
lords?
no, you presumption comes if you say that he had a knowledge, therefore he accepted. Then you presumption against him. You can't build up a new case and read presumption into it.
My lords, on presumption part, I'll be relying one judgment. Your lordship can.
I understand that's the simple funda. You tell me whether he had a knowledge that doctor has demanded money.
Yes,
If he has a knowledge,
yes,
show me from record. And you read 313, he says that I have accepted this money
for the purpose of procuring plastering materials.
Plastic material.
Yes.
You are trying to show from the record
That
there
plastering
was no
materials
occasion
were-
for him.
Yes.
That he had demanded for himself then, not for the doctor. Then why have you prosecuted doctor?
সেটা মনা করছি প্রথমে
Prosecuted. Then the entire prosecution story falls. Collapse there.
That is our difficulty because this we have a dented evidence of PW 3 and 4.
Very bad. Acquitted. There is nothing. Very badly.
That was all that I had in this forum.
Right,
my lords.
right.
Apart from this, nothing was there on records. So I was harping on that.
Very difficult because you have put forth some the prosecution case in a different pedestal.
Yes.
Today you can't turn around and say that leave
Exactly.
the doctor apart. I will build up a new case against you, and I'll put you on under the age of 20.
That upon nothing was there on record.
If the doctor would have been there,
Yes, my lord. Things would have been different.
then the story would have been
Different.
This statement has been recorded only to acquit the doctor at that point of time.
Anyway,
Anything I have to submit? Not necessary.
you want a conviction?
No, no.
Now I'm convinced and acquitted.
No, well,
And you want to deconvince me and
no. Obliged.
simple. We need not go into
Yes,
nitty-gritty
ma'am.
of this. Simple. Keep it. Cosmetically.
Yes, ma'am.
And then they could not prove the case.
Obliged.
Yes.
61.
Yeah, 36. Keep it. Yeah.
Blood. In this matter, my lord, my beg your lordship, pardon, rekindling your lordship that your lordship has already heard, only my lord was pleased to carved out the point, the intention. 307, the court has been convicted for 307 IPC.
Yes.
Therefore, lordship has said that any judgment to put on tax to both of us to find out any judgment in this regard.
Truly speaking, I forgot what.
Yes, that 307 attending circumstance, genesis
arising out of the civil nature, civil litigation between the uterine brother. Both the parties are uterine brother. And my lord, the petitioners are two, and the victim is one, and the nature of the injury simple in nature, and the manner of assault. There is no aggravated manner or repeated assault.
Vital part, the body.
Vital part, neck
and head.
below the ear, but very simple in nature. And besides that, the manner of assault, there is no repetition of assault. There are only two injury. One injury is only
Weapon?
My lord, weapon is set with a crowbar, but there is no corresponding injury. My humble submission, the weapon of offense is crowbar, but that is no corresponding nature of injury. It is simple in nature. And so from the attending circumstances, that the intention cannot be inferred.
You are trying for 313.
323 and
323.
There is one judgment, if your lordship has,
Yes.
since your lordship has directed, I have with your lordship permission.
Agreeing, then I will not read that.
What happened in this case, my lord? The charges against this petitioner and the other co-accused persons, 448, 354, 323, 294, 307, 290, 223, 34 acts, my lord.
Yes.
They have acquitted all the charges, my lord, except 307 and 34 accusation. Two of them, my lord, these two petitions, my lord. Here, my lord, Pedal 5, 6 are the eyewitness and injured witness, and doctor is the Pedal 8. But Pedal 5, my lord, the informant, my lord, the wife of the injured Pedal 6. She has stated that this accused, the petitioner, Khirot, assaulted by means of a crowbar. And another petitioner, my lord, he assaulted by means of a cautery to the neck. So there are the allegations there, and that doesn't mean, my lord, corroborated by the
doctor
medical evidence, my lord. There are injuries, my lord. So regarding, my lord, with regard to 307, my lord, since injury on the neck, my lord, is the vital part of the body, and assaulted by means of a deadly weapon like cautery and crowbar, my lord. So
what he says that the injury has to be relatable to if they are holding, suppose they are holding deadly weapons, but they don't use it in the vital part of your body, then intention is
intention there, my lord. Since neck, my lord, neck is the vital part of the body, and their intention to commit the murder. As because they have been acquitted from the charges 24 by piece, my lord, by the same court, my lord, like the same set of evidence, my lord. So, but 307 is, my lord, clearly made out, the neck injury is there. For that, they have been convicted. Two courts, both the courts, my lord, they confirm.
307.
307. And sentence is 5 years, my lord.
That husband is also similar. Page 10, paragraph 10 is very important.
Having considered the fact and circumstances, yes,
Similar. Akin to the present case, some extent.
repeated or several.
Yes, that.
The accused, you know, the tilted crowbar blow, aiming his head, which struck on the left ear, causing the bleeding injury. Pedal 5 during cross-examination, the chief examination chief has stated that the accused Khiro, the tilted crowbar on the head, the left ear. My friend saying that the hiring on the President of America.
That was an intention.
Well, that was
but here what he says that is a case of single blow.
Single that the
Single
on the
blow.
vital part of the body and weapon offense is the
Single blow holding deadly weapon, single blow, no intention. That's what he says. He had I been intention, I would have given multiple blow and eliminate him. I had no intention to kill him. So therefore, despite the fact that I am equipped enough, I had not done it. Therefore, I had no intention to kill him. That's what his case is.
And the court finding Pedal 5 during examination chief has corroborated such fact, only added that the said cautery blow struck the right side neck, causing bleeding injury. Pedal 6 during his cross-examination chief corroborated that such evidence of Pedal 5 stated that accused Gangadhar did a cautery blow, aiming his struck in the right side neck, causing bleeding injury. The medical officer, Pedal 8, found one abrasion on the upper part of the neck, another on anterior aspect, which was opinion on the
Simple
cause by
injury.
hard burn.
Simple.
Hard and blunt open.
No, injury, nature of injury, simple.
Simple.
That is the matter of the.
Let us use the judgment and give him the benefit. No repeated injury, no
Yes,
intent.
repeated as well.
What was the sentence?
5 years.
5 years.
5 years.
Undergone?
That Lord from the record, few
Hmm?
they are all through on bail, and after this judgment is passed, they have been made over to jail custody. That period,
Must have undergone.
yes,
during
that
course of-
from
the
the
appeal period and also the investigation.
yes, have to be calculated only.
You just check it up and tell me tomorrow.
And one paragraph point out, my lord,
That
paragraph 22.
from the from
Paragraph 22 of the appellate code.
Appellate code.
My lord. The medical report marked as exhibit 3/2, the injury sustained on a parietal region of the left scalp and on the upper part of the neck. The patient was referred to neurosurgery department, SC Medical College Hospital, Kotak, and the medical officer reserved the opinion. The injuries are the vital part of the body and the same were sufficient to cause the death of the victim. So considering nature of weapon use, crowbar and cutlery, the express intention of the accused, nature of injuries, severity and a persistence of the blow given, I am convinced that.
How much you have undergone?
Yes, but from the date of judgment till date, Milord, and prior to that part from the LCR.
I can see, I can't equitable is not true.
No.
Only we can play it up in sentence.
Reduced to 3,000. Therefore, this
But the sentence part is two facet of it. One is maintaining 307 sentence and reducing to 323 in sentence. These are the two issues.
That judgment.
As because there are other sentences 324, that has been managed. They have been acquitted from that judgment. So
Because 307 convicted is the other thing, other aggravated offense convicted. So 323, 324 they
reduced.
acquitted. So tell me so that
from the
we
LCR,
we will see what the best could be done.
Lordship, permit me to look into the
Substantial period if he has undergone, then by retaining 302 to reduce the sentence to 50.
That judgment,
fine will be there heavily.
In that judgment also it has been reduced to 323 or 324.
Fine. Incident is 2001.
Yes.
And what is the age of these people?
Appellants.
Two malad, I did filing number 51.
41.
Chaudhary. It's no 146.
51.
If you see the charge sheet, then you will get it.
That's it.
Charge sheet there.
Yes, this is what is his name? Name is
Kirod Kumar Das.
Gangadhar.
Gangadhar
Das.
Gangadhar, Kirod Gangadhar.
Yes.
Kirod, year of birth 1966. Kirod. Just see, year of birth 1966. Kirod. So 66 means what is the age now? Check it up. 66. And Gangadhar Das, 58, 1958. So age क्या है? 66, 58. हाँ 58, ठीक है. And 58, 66, 66, 58, 66 is age up today.
They are alive.
Alive.
They are
alive.
No, they must be alive.
Only I will say not the calculating the period undergone.
Period undergone you calculate.
From the from the LCR I have to.
Copy you. I'll put it tomorrow. Huh?
Tomorrow, Monday or Tuesday. Tuesday better. One day.
Tuesday, huh?
Regarding the period undergone or the period in custody.
Period in custody.
Total period
in custody. Das learn for the petitioner shall ascertain
the period
In custody.
period the petitioner have already undergone.
Tuesday, one day. Obliged.
Only to that extent we will see.
Yes, yes.
Yes.
62. Lots of 62 and 63. Both are similar, but vigilance, let's see, here is the council. Vigilance can help. Lordship here, Lordship against.
You are there, 62,
62 to 63.
62, 63. It's a das.
Lords,
Ready?
Lords, I have to take instruction because he says one of the major crush of his argument, non-compliance of particular statutory provisions. I'll come back to Lordship with the positive instruction.
In fact,
Let it retain in the board. Retain.
wow, I pray Lordship because Lordship kindly see my.
Supplementary continue board.
Since 2022, my account has been freezed, Lordship, and I am no way connected so far the
No, no,
principal.
they're sorry,
When I'm making a
they're-
submission, don't, I'm just making submission to court. In fact, Lordship, since the 22, both the accounts, Lordship, in separate time, I have no connection with the accused also. And interestingly, in this case, Lordship, they have refused, Lordship, the account of the principal accused.
You are not the accused.
No, I am not the accused. And Lordship, 102 is better. Supreme Court recent Lordship and this is judgment. Either offense under the PC Act. And they have resetted for feasible account under section 102 of CRPC. So not permission in the eye of law, Lordship can judgment on the very self-same fact. It has been.
So let him seek instruction. If we releasing it, it's all right. Why should you labor on?
Lordship, since last 2 years.
Many in 357 cases, many cases Mr. Das has solved by getting instruction, and many cases we have disposed of on the basis of his instruction.
And in fact, I have not seen that judgment. Most likely, he has praised that judgment pertaining to
Compliance of 102 and all. Right?
no, that compliance to that attachments, my lords. Here is the case of seizure, my lords.
Seizure, the question
Seizure.
of seizure.
So attachment is another section, my lord, of the Special Court Act and Prevention of Corruption.
Here,
I'll
on merit, we'll have to hear it.
Yes.
But if you can sort it out by getting instruction, sort out.
May without taking instruction, begin in similar matter, taking instruction. If the petitioner's counsel take the instruction from his client, if he's inclined to give any kind of bank guarantees, it can be shut out. I will also take instruction. Let him take instruction.
Judgment is
that judgment is destroyed, Lord. That's no.
Please go through that. Please go through. Directly on freezing.
No. That's attachment.
No, Lordship.
18.1 is the attachment, sir.
Lordship, kindly.
New provision has been appended in the new 2018 Act, Lords. That she can't declare.
Oh. You seek instruction. I'll let it be there in the supplementary list, retain it because it's 357. Tuesday or Monday or Tuesday.
May I pray,
Let
Lordship,
it be retained in the
can
supplementary.
it be in Lordship in the top of
Sunday.
it so that
Top of list, bail is much more important.
but here, Lordship, I'm suffering from financial.
It's all right, but it will reach, don't worry. Tuesday it reaches.
After orders, Lordship, and after admission the seat.
Orders are okay.
Order.
Order, let it be on
Orders.
orders.
Orders, Lordship. Let it be on orders.
Okay. Instruction.
Tuesday, yes. Lordship.
My Lordship fixed a date.
Tuesday.
Tuesday.
And Lordship, that part.
Tuesday, 13. I'll take it. Okay, so that because that judgment, Lordship will give another 1 2 days. Let it be on 16. 16, no. Report.
64.
64. 16 lordship. Okay. Again, it is Friday lordship.
Friday is not good day.
Not good lordship. But 14, let it be on 14, Wednesday.
Then at 20th, my lord, it's not auspicious.
Monday is auspicious.
No, that is not Monday also.
Tuesday
That is again Tuesday.
No, that's the opening of that particular week.
In the same lordship, some objection will there lordship that will take steps for if that is so, then
I'll dispose it of 457. I'm wondering why it is pending so much.
lordship.
I can dispose of. He says he'll seek instruction. Otherwise, I'll take 10 minutes to decide.
And let the petition,
Decide.
if he is otherwise ready for this bank guarantees, my lords.
That also is seek instruction.
Yeah, I'll take
Some security, something.
Yes.
Without delving all those
liberal-
matters.
Liberal lordship.
Ah.
Lordship again.
Yes.
If the bank guarantee is similar, so now also it can be. So I stand for
No,
that.
bank guarantee has to seek instruction.
That is
Oh,
only
yes,
bank-
well,
Equivalent
correct.
bank
Your
guarantee,
lordship
there is
correct.
no
He has to take instruction. Correct.
Can't do that.
You correct. He cannot take a decision alone.
64.
64, my lord, the petitioner was facing trial before the learned JMFC Barampur Millet in a case under section 341, 324, 323 of IPC, my lord. And learned JMFC, after conclusion of trial, acquitted the petitioner under section 341, 323, 506 of IPC, convicted under section 324 of IPC, sentenced to undergo RI for 6 months. And the same has been confirmed by the learned additional session judge cum.
How much you have undergone?
Judicial judge. My lord, in this case, 5 witnesses have been examined, my lord.
Undergone. Period of
Undergone, my
undergone.
lord, exactly, I have not.
Find out period of undergone because see the incident.
6 months.
Huh?
6 months, my
and
lord.
fine.
6 months and fine.
You might have
It is a
undergone
case,
fine.
my lord.
6
Lord,
months, only
If
6
you have
months.
undergone 1-2 months, I'll reduce sentence.
My lord, reduce also, my lord, is a case of acquittal.
Huh?
Also is a
No,
case
no.
of.
My lord,
I am placing, my lord.
2000, see, 2001 incident.
PW1 is the informant, my lord, injured, my lord.
Convicted by 2 courts.
In this case, the
1 and 2.
scriber of the FIR has not been examined, my lord. In this case, my lord, IO has stated, I have not asserted who scribed the FIR, and the wearing apparels were not bloodstained. Did not
Witness is
see
there.
any cloth.
Injured witness is there.
Injured witness is there, my
Then
lord.
how will you get over the injured
And
witness?
doctor's evidence also there. Pedal 5.
No,
1, 2 and 5. 5.
instead of trying
Clear.
unnecessary for this thing, you just see how much you have undergone. I'll reduce the sentence to that.
6 months imprisonment. madam.
Is arrested. IO has stated the petitioner was arrested. In this case, no weapon of offense has been seized. IO has stated.
What are the injuries?
Very clear.
Injuries?
Injury, my lord.
Simple
there are,
injury.
No, madam. There are, my
Simple
lord.
injuries.
For that in 24, my lord. As per injury report, PW1 sustained an incise wound with the fresh bleeding of size 1 semi into 1/4 semi, skin deep on the modinal end of the middle of the left palm. Similarly, he has also found incise wound that is half inch into 1/4 semi, half semi into 1/4 semi, skin deep on the lateral and on the middle of the left palm.
All the injuries are
Found
simple.
another bruise,
Simple in
slight
nature.
circumference, lower lips. Pedal 5, both the incise wounds are simple in nature,
Simple.
caused by sharp cutting weapon.
All the
Of that,
injuries are simple. All the injuries are simple in nature. It has mentioned.
Therefore, you have been acquitted from 307 and all.
My lord, the weapon of offense has not been seized. IO has stated, my lord, the wearing apparels or the bloodstained has not been seized, my lord. And the no mark of violence in the spot, nor I find any bloodstain on the soil on injury at the spot. And the investigation does not reveal any regarding the staying of injured at hospital. IO has stated, my lord, in his evidence. And the informant is a antisocial, my lord, and he has stated, I am involved in 3 cases, my lord. In his evidence, my lord, PW1, W1, my lord. In cross-examination, for my lord, there are 3 criminal cases in my name. I know the accused person since last 10 to 12 years. I do not know right and
How does it make it, if the victim has criminal cases, you can beat? You
My-
say, what is the evidence against you, you tell. He may be whatever.
yes, my lord.
He may be whatever. These are immaterial. What are the material which has come against you?
Against my
You
lord,
have to get over the evidence of the injured witness.
only
Get
independent-
over the evidence of the doctor.
The
Both the evidence is corroborating.
Para 6.
So
the
therefore,
independent witness, my lord, P33 not.
maybe, but how to get over injured witness? How will you get over?
Para 6, my lord.
And that corroborates with the doctor's evidence.
Doctor's evidence.
That's enough for 323.
24 condition. 6 months.
6 months conviction.
Just take it up, how much he has undergone. I'll put it
He has been arrested on election day. As
Yes, not like that. You don't research it. You tell me. See the record and tell me. I'll put it on Monday in the supplementary only. You can take disposition. The substantive period, if you have already undergone, reduce the sentence to already undergone.
Must be undergone, my lord. Yes, my lord.
Unless you see the record, you can't make a definite set. If you are trying for an acquittal, he is a government servant.
No, my lord.
What is the age?
Age 30 years. 30.
32 years and 32 years. Let us see the 30 years. Yeah.
30 years.
Sorry, you have not.
On 4/9/2001, he was arrested, my lord. I have stated.
No, 81 bar year.
I arrested the accused Haripatra on 4/9/2001. I'll verify the
When he was released, that.
I'll verify the LCR, the exact.
Okay, put it on Monday, yeah, for verification. For verification for the sentence period. Yes.
65. Taken up to use supplementary.
Supplementary. You will tell. Yes.
65 mala.
Monday I put it. You just. Huh? You just check it up from court. Yes.
My lord, this is that, my lords. Item 65, my lords. I was mentioning at the time of lordship said after the lunch hour that this matter taken over 2:45 minutes. I'll get the time to finish it up, my lords. I prepared, but I have to leave to my house for personal matters, my lord. At this stage, if I open up, it cannot finish it up.
Friday, he also doesn't work after 4
No,
o'clock.
no, I wish him all the best for a happy weekend.
That's the reason he's standing here. He's not coming to the front.
Not only standing, the flash of smile on his face rejuvenates.
When next week, when
Any date, continue
let's
to
see,
my-
they partly heard. Otherwise,
My lord,
forget,
I am
saying
completely ready, my lord.
51.
My lord, I could dare to request a lordship that it take it up to 2:45, so that will get the time to place out, my lord. I'm fully ready. Now the ball is in their court, my lord. Let them fix any date convenient to them.
12, 13, 14, any date, your lordship, at 2 o'clock, my lord.
Yeah, I agree, my lord. I agree with you, my lords.
So
2
nothing
o'clock.
can be discussed.
Correct.
Lordships have already heard it.
20.
Not 21st of Sombar. Anyway, then it's a Mongol version.
The coming week is jam packed.
My lord, week
The
after-
same thing will happen. Waiting whole day and.
Correct,
end of
correct.
the-
week after next. But because your lordships are part-headed, so my lords, if you are.
Because of these bail matters and all, I'm not able to,
In front of the lordship saddle
pass
is
up.
huge responsibility that bail matters.
Thanks, my lords, that is a very big responsibility. But I don't think, because he will take roughly, I think, half an hour, let's say. Then Just in reply.
Actually, my lord, let
Please
it,
cut
let it,
short.
let it.
I don't think it.
No, I will not cut short, my lord. With great respect, my lord, I'll be happy if my learned friends cooperates with me, my lord. I'll place the case, not that to exaggerate, not to repeat any points, my lord. What I said, I agree with my lord. Let's fix the date at 2 p.m. so that I can fish. Any date at 2 p.m.
Tell me who is there.
Any date to 2 p.m. I agree with me. So that it can.
22nd at 2 o'clock. 22nd at 2 o'clock. And get a written note also.
I've already prepared, my lord. My lord, had your lordship allowed me to place at 2:45, I could have finished. But so many matters are there.
Today is a Friday, it's all right. But sometime if you can cross beyond 4 o'clock also.
My lord, I promise this on report.
Someday we have to hear it.
My lord,
Let it be, even if it is 4 o'clock, we will start. By 5 o'clock, we will finish it.
But not on Friday, my lord.
Not Friday. I'm not.
We are completely surcharged with different.
No, Friday I'm also not suggesting. It's sometime in between.
No,
even it is delayed and let us finish it up.
No, on 22nd, I think we'll. 2 p.m. I promise, my lord, no point will be repeated, my lord.
Entry model is my friend.
Entry model.
Thank you.
Yeah.